I has been filed for interim bail on the ground number 2.
Supplemental list. Item number 1.
Yeah, please. Even you not very directly take instruction regarding the status of the representation filed by the petitioner.
IAC Komna is this. Unmute करून दो again. Unmute करून दो IAC.
IAC कौन थे?
इधर IAC कौन होता
अरे जो item 3 का 10
नमस्कार
आइटम 3 टा
310.
वो फर्स्ट टेक अच्छा प्लीज ठीक है
Item 3.
सर नमस्कार
ये लोकनाथ आपनो ना कौन आईआईसी
सर कुळमणी गुरुदास सर
कुळमणी
गुरुदास
कुलमणि गुरुदास
सर
सी कुमना पीएस कुलमणि गुरुदास GURUDAS लोकनाथ सपनामी अच्छी कि आपण पाखरे
सर तार कांटेक्ट करथलो सर बर्तमान से आसीनी पहुंचनी बर्तमान सर
अच्छा हो आसुची तो
हां से बाटरे अछि गेले सर लोकेशन टेस्ट करथली सर
आसिले सरकारी वकील को जणेबे हम टेक अप करी हला
हां सर
आपण एटा वाइटला 10:30 रे सुधा पहुंचेबा पई हां और ठीक अछि आपण वेट करन तब ये नेक्स्ट
हां सर हां नमस्ते
Item 1.
ସେଟାକୁ ଇଏ କର ସେ ଆସିଲେ ଯେତେବେଳେ ଯେତେବେଳେ ଆସିବ ଇଏ କରିବ ଏ ଯୋଉ ପର୍ସନାଲ ଆପିଆରାନ୍ସ ଆଇଆଇସି ଆସିବ ଆପଣଙ୍କୁ କଣ୍ଟାକ୍ଟ କରିବ ନା ସେତେବେଳେ ପୁଣି ତାକୁ ଇଏ କରିବ ତାକୁ କାହିଁ ଅନ୍ କରିଦେବେ ସେ କୋର୍ଟ ପ୍ରୋସିଡିଂ ଦେବେ କଣ ହେଲା?
Yes, my lord. They are giving the compare report as per the order. They are reference report the CGM and as per the order of the Learned Civil Judge Senior Division Barampur Ganjam. LA case number.
Representation dispose of land.
Yes, my lord. That dispose.
तो सेती तो करता हम देखो the learning council for the state has produced the compliance report obtained from so and so dated so on is taken on record conference proceedings go yes next
Item 2.
now the copy दे दो दे copy ठीक है next they have disposed of my appeal they have rejected
my lord. That on the ground of they are held the appeal, but they are not paid the amount, statutory amount. The appeal is dismissed.
The learning council for the state has produced the compliance report taken on record content which states not used.
Item 4.
Right. On the Mr. Naik password.
Item number 4 for
On the Mr. Devasis Naik. Password.
My lord, I was going through the notice given in the cause list. There is a mention that objection to the opposite by opposite parties to additional affidavit filed by the petitioner in response to report etc. is not filed, but it is filed that is in flag D. I verified, and if I think if they have not just a minute, if they have not received it, I am serving a copy today. so that they cannot take it, say that they have not reached it because
No,
that
no. Are you aware about this?
Absolutely.
Or you password? Two days.
sir, online ଅଛି ନା?
Only way.
Next.
Item 5.
I have got the petition. I have the notice to file so cause my
May your lordship.
You're for?
Sir, opposite party, behalf of,
Who is that?
sir, on behalf of senior Satyasindhu Kashyap,
No, who is that opposite party?
I was here, sir.
Yes?
I was here.
I was here. Ah.
My lord, I'm representing an auto place for there's a pyramid in my family. My lord, kindly permit me.
Yes.
Actually, my lord, that order, my lord, has been passed. It has been complied with.
Where is that document?
I'll file you affidavit. 7 days. 7 days, my lord.
No. The order. We just want that order. That's all. We don't want any. We just want an affidavit with the order passed. That's all. Because the time which you have given was for 3 months from the date.
Yes, my lord. There has been a personal hearing, so my lord.
No, it's all right.
And-
If it has been disposed of, please file that order so that.
7 days. 7 days, my lord. I'll file it.
Mr. S.S. Kashyap, Land Council, appearing for the contempt or opposite party submits. You have got the instruction that representation.
Yes. I've
That
got
the
the
order, that the order has already been complied with. That the order dated so and so passed by this court in WPC number so and so already been complied with, and the matter may be taken up a week after, so that he will file an affidavit to that effect along with the order passed. Put up this
Deeply.
matter on today is 13, so we can take up this matter on 20th.
Yes.
On 20th of November 2025. Yes.
Oblige, deeply.
Oblige.
Yes, Mr. Naik, which matter?
Item 4.
4 years.
This is a restoration application.
Restoration of what?
It's a writ appeal that was dismissed for non-prosecution.
Which one?
There was a 23-day initial delay, but after my law, the director stamped reporter, because of an objection taken by the learned senior counsel, that the limitation application was not filed with the restoration application.
Now you have filed the limitation application.
That was filed long back, my lords.
Okay. So the condonation of delay and they have filed the objection also.
Well,
So
the principle that was taken in the objection was that since the limitation application was not filed with the restoration application.
yes,
Delay.
Mr. Rotha, what do you say?
My lord.
Let this delay be condoned and let the matter
It's
be,
not an 87 days delay, sir.
matter be restored and let it be heard on merit what is there. The CMAPL read appeal ta dismissed easy for default. Eguda kono. What is that order? जो रीट अपील ऑर्डर था कहीं yes Mr. Nayak, रीट अपील ऑर्डर तक है
Writ appeal is it's there. Order number 26/9/22.
to pay cost to the bar association
Well,
so for the employees that will be utilized.
well.
So what amount you say so that the staff will go to see Baliyatra? Still on your own
2000 rupees.
687
687 9, that point I'll argue with from
again you are arguing, sir.
No, don't argue.
No, but my learned senior
The-
is saying
Please, we want to restore the
My lord,
status.
yes,
The amount you pay and we'll say that the amount will be deposited by certain and it will be distributed equally between the employees of the High Court Bar Association. That's all.
5,000.
No, no. 5,000 you can buy that Moody Mr. You suggest the amount is 5,000.
Sir,
5,000 Bar Association.
sir, and you are food corporation, you are controlling the entire country. That must be some exemplary cost.
Supply little food to everyone.
Sir, and you
ନାଇଁ ବାର ଆସୋସିଏସନ ରେ ଏମ୍ପ୍ଲୟିଜ ମାନେ କେତେ ଇଏ ଜାଣିଥିବେ କେତେ ଅଛନ୍ତି ପ୍ରାୟ ଷ୍ଟାଫ
ଆମର ସାର୍ 15 ରୁ ବେଶୀ ଅଛନ୍ତି।
25 ଜଣ ଅଛନ୍ତି।
25 ଜଣ
କେତେ ଅଛନ୍ତି?
1000 ଟଙ୍କା ହେଲେ 25,000 1000 ଟଙ୍କା ଲେଖା ଦେଲେ ତାଙ୍କୁ ସେ ଯିବେ ବାଲିଯାତ୍ରା କି ବୁଲିକିନା ଆସିବେ 25,000 pay 25,000
Kindly consider.
রিট appeal লেখুন আর IN number delay টা কোটা আছে IN number so and so this is an application for condonation of delay period the governments taken in the interim application so also the objection filed by the opposite party after hearing the land and counsel for the petitioner and land senior advocate appearing for the opposite party we are inclined to condone the delay in filing the CM appeal. Accordingly, delay is condoned. After CM appeal, the CM appeal has been filed for restoring the writ appeal that is WA number so and so to file, which was dismissed for non-prosecution on 26/9/2022. Then further, after hearing the land counsel for this also grounds taken also, the matter is restored to file subject to deposit of rupees 25,000 by the appellants in the High Court Bar Association within a period of 1 week. If the same is deposited, the same shall be equally distributed among all the employees of the High Court Bar Association. And the receipt regarding deposit of the rupees 25,000 shall be produced before this court on 25/11/2025.
Before 10 working days.
10 working days होंगे क्या कि 2/7/9 नहला 27 तारीख रे रिसीप्ट प्रोड्यूस करेंगे 27
sir, date
ରଖିଲୁ ପୁରା 27/11 ସେ ରସିଦ ଟା ପ୍ରୋड्यूस କରିବେ ସେ ଯୋଉ डिपोजिट ଟା ତାପରେ ହିୟରିଂ ହବ ରିଟ୍ appeal ଟା ରିଷ୍ଟୋର ହେଇଗଲା ତ ଗୋଟେ ଡେଟ୍ ଫିକ୍ସ ହବ ଇଏ ପାଇଁ
ଏଇ ତ ଆପଣଙ୍କ
ହଁ ଠିକ ଖାଲି ସେତିକିଟା ହେଇଯିବ
Item 7.
ଦିଟା ମ୍ୟାଟର ପାଠାଡ ଅଛି ଦିଟା ନା କେଇଟା ତିନିଟା ଗୋଟେ ପାଠାଡ ମ୍ୟାଟର ଆଗେ ଧରିବୁ ତାପରେ ଯାଇକି ତିନିଟା ମ୍ୟାଟର ପାଠାଡ ନା
7 report ଆସିଯାଇଛି
7 report ଆସିଛି
ରିପୋର୍ଟ ମାନେ
ସେଟା ଲେଖା ହେଇଥିଲା ତାର କ୍ରିମିନାଲ ଆଣ୍ଟିସିଡେଣ୍ଟ ତା ଇଣ୍ଟରଭେଲ ପିରିୟଡ
ଆଚ୍ଛା
ରହିଛି
ଆଚ୍ଛା ଯୋଉ
ତା ଏମ୍ପ୍ଲୟର
ପମ୍ପରେ ଯୋଉ କାମ କରୁଥିଲେ
ଆଉ ଯୋଉ
ନାଲକୋରେ ଯୋଉ
ନାଲକୋ।
କାମ
interview. Paper ଉଟା ଯୋଉଟା ହଁ
ଆଜ୍ଞା injured 9 is injured 10 is wife five years 5 years बार 11 97 till 2 5 2 5 2 ବର୍ଷ ତାପରେ ଏଠି ହେଲା 24/11/2000 2 ବର୍ଷ 2000 15/12/3 15/12 11 ମାସ 2 ବର୍ଷ Only question was that whether the minimum punishment prescribed on the statute is not 10 years extra of 10
We have heard his matter,
My lord.
and he has placed a judgment of the Honorable Supreme Court also. In that judgment, it was discussed as they are also 304 part 1 and the Honorable Supreme Court has made it 7 years. So accordingly, we called for this report and become the Surinder Kumar versus Union Territory versus Chandigarh. If you law searching for a IV place, injured window.
It's 60. I'm informant in this case. I know the accused in the dock. Injured. Yet, I know the accused in the dock. My father was murdered on 4/11/97 at 10:30 p.m. Our family consists of my father, mother, myself, and my sister, who are staying in quarter number 7 in Bridge and Roof Colony, FCI Township. Accused Gokul Samal was then staying in our adjoining quarter number 6. My father returned from duty to our quarter at 10:15 p.m. After taking his meal, when he was about to go to his bed, heard that accused Gokul Samal has switched off on his tape recorder and it was loudly sounding, causing disturbance in the children's study and sleeping, for which my father then asked the accused Gokul Samal went and asked the accused Gokul Samal to slow the sound of the tape recorder. Prior to that, my father had also warned the accused to prevent him from not to create any sound by tape recorder and not to waste the water by keeping open the water tap. Hearing this quarrel between my father and accused, I came outside and saw that quarrel. My mother and sister also came to outside of the house along with me. During this quarreling, accused suddenly entered inside the house and brought a GI pipe and chased my father to assault. Out of fear, my father ran towards quarter number 1, and near the quarter number 1, the accused dealt a blow by the GI pipe to the head of my father, which hit above the left eye brow. As a result, my father fell down, and thereafter, the accused gave 2 to 3 blows by means of GI pipe, almost in the same place on the head of my father. When I went to the rescue of my father, the accused dealt 2 successive blows that GI pipe, which hit on my backside neck, and the back. I fell down due to the assault when the accused went to his house with the said GI pipe. Thereafter, my mother and some neighbors came to the spot and we took our father to our quarter. The head injury was bleeding, and the head injury was bleeding was tied by means of a prop of my sister to check the bleeding, and thereafter my mother went and informed the FCI hospital over phone for sending of an ambulance vehicle. Myself, my mother, and my sister took our injured father in the said ambulance to the said hospital. After reaching the hospital, I went to village Ekagradia to call my paternal uncle Biranchi, Biranchi Kumar Bhutta to the hospital to see my father. Village Ekagharia is about 1 furlong away from the hospital. Due to severe pain for the assault on me, I was the only attendant to my father for the night. I could not lodge the affair in the night of occurrence and lodged the affair on the next day at 9 a.m. This is the written report such and such typed by my Exhibit 3, 13 and 13 by one man signature. As the doctor doctor in charge of the treatment referred the case to Cuttack. My father was moved to Cuttack at 11:30 am. My father was at the coma stage from the time of assault till he was removed to Cuttack Hospital. My uncle, my mother, with a medical staff, took my father to Cuttack for his treatment. As there was none in the house, I remained in the quarter with my sister. I came to know later that my father was admitted in the neurosurgery department SCB Medical College Cuttack. After 4 days of the treatment, father died at the Cuttack hospital. The police officer of FCI made a spot visit immediate after the receipt of the affair, and the spot of quarreling and the place of assault was shown by me to the police. The place of murder was bloodstained. The police see the bloodstained earth and prepared the seizure list in my presence. This is the seizure list marked Exhibit 7. Exhibit 7 by 2 is my signature. The blood-stained banyan of my father, the blood-stained frock of my sister, which was tied in the head of my father, and my blood-stained full shirt produced before the police, which was seized. This is the blood-stained frock mark MO VIA V. This is the full shirt mark MO V MO 5. And this is the banyan of my father. Police prepared a seizure list already marked Exhibit 8. Exhibit 8 by 2 in my is my signature. This is the said GI pipe in which my father was assaulted. So also myself. Cross examination. I am a plus 2 student. I wrote the affair without any instruction from others. I was examined by police about 1 hour after the lodging of affair. The distance from the quarter 7 to quarter number 1 would be 30 cubits. It was 10 a.m. in the night, 10 p.m. in the night when I went to bed. I am the first man of the family went to the bed on that day. Out, but quarter consists of only one bedroom, or quarter bedroom, and a room where we keep our motorcycle. Besides, there is a kitchen and bathroom. The accused was not pulling well with us, even prior to the date of occurrence. For this, operating the tape recorder in the loud voice. It is not a fact that I have stated in the affair that the accused chased my father with GI to assault him. Out of fear, my father ran towards quarter number 1 and accused Gokula dealt a blow by means of that GI pipe on the head of my father above the left eye row. As a result, my father fell down on the ground, and that immediately thereafter, accused Gokul Samal again gave 2 to 3 blows by means of GI pipe at the place of previous injury. I do not know if the accused is occupying the quarter number 6 without the permission of the authority, one side of the door, and quarter number 6 was then found open at the time of quarrel between my father and the accused. I saw the quarreling between the accused and my father standing on my own veranda. My father was standing in front of the house of Gokula, and Gokula was standing in his own veranda at the time of quarreling. I have no talking with the Gokula. The, हाँ ତା ଘର ତ ସିଏ ବାରଣ୍ଡାରେ ଛିଡା ହେଇଥିଲା ଇଏ ତାଙ୍କ ଦୁଆର ତଳେ ଥିଲା ସିଏ ବାରଣ୍ଡାରେ ଛିଡା ହେଇଥିଲେ ଇଏ ତାଙ୍କ ଦୁଆର ତଳେ ଆଜ୍ଞା in his, and Gokula standing in his own veranda. Okay. I have no talk with Gokula during that quarreling. It is not a fact that it is false to say that the accused brought out a GI pipe from the house, chased and assaulted to my father. It is not a fact that my father, under the influence of liquor, have assaulted the Gokula 4 to 5 times prior to the date of occurrence, objecting to the operating of the tape recorder with loud voice, and was also threatening to oust him from the said quarter, from his unauthorized occupation. It is not a fact. At the time of occurrence, my father, under the influence of liquor, entered inside the house of Gokula and dragged him to the outside of the house from the place of his eating, threatening him not to allow him to stay in the said house, as he is disturbing in staying of children by operating the tape recorder. All the occupants of the quarter number 2 to 8 has to pass through in front of the quarter number 1 to cross the main road. It is not a fact that my father passed through Gokula by dragging up to the quarter number 1. They are eating him not to allow him to continue in bottom 6. It is not a fact that while my father was dragging by pulling the hand of Gokula and Gokula was trying to pull away his hand from my father, the hands being slipped away, my father fell down over a stone near quarter number 1. As a result, my father sustained bleeding injury on his head, and the other three injuries of my father was uh, uh, father was spotted due to his coming in contact with caused due to his coming in contact with the fallen tree and it is the branches. It is not a fact that I sustained injury on my back by coming in contact with the said branch of tree, but not for the assault by Apid Gokula. It is not a fact that we started a false case for our previous enmity. It is not a fact that my father was not sustained by this MO fight.
The other line is P.W.
That period 10.
Contact this one.
Wife, the mother of the wife of this. The deceased is my husband. I know the accused was staying in the adjoining quarter of my quarter. The occurrence took place in 4/11/97 at about 10 p.m. and the place of occurrence was in front of our quarter. 8 to 10 days before this occurrence, my husband quarreled with the accused by giving a caution not to operate the tape recorder with loud sounding, causing disturbance in the study of the children, and he should not keep the water tap open as the water is being drained out. At the time of occurrence, my husband went and objected for operating the tape recorder in a high sound, and after the the quarreling, hearing the quarreling, I came out the quarter. In midst of the quarrel, the accused went inside the house and returned with a GI pipe and chased my husband, and lastly assaulted by that GI pipe on the head of my husband, 3 to 4 quarters away from my quarter. That is, in near the quarter number 1. When my son went to rescue of his father, then the accused also assaulted him in the said GI pipe. I immediately informed the ambulance to take my husband in the ambulance and tried the uh, place of the injury uh, in the frock of my daughter. On arrival of the ambulance, I took my husband to FCA hospital. My injured husband was admitted in the FCA hospital. The scene of my son, sense of my son returned, but the sense of my husband did not return from the time of assault till he was removed to Kotak. Myself, my dear Biranchi Hota, with an medical staff, took my husband to Kotak. In that unconscious stage, after 3 days treatment at Kotak, my husband died. Getting the information, the Mangala police came and held the inquest over the dead body and sent the dead body for post-mortem examination. This is the GI pipe by which my husband and son were assaulted. Cross-examination. My son first came out from the house. Agur ହେଇଯାଇଛି। My son first came out from the house hearing the quarreling of my husband and accused Gokula. It is not a fact that I stated to the IO that apprehending some danger to my husband, I called my son and daughter from their bed and sent them to protection of my husband. In protection of my husband, my son has followed my husband to save him when the accused was chasing with the GI pipe to assault my husband. It is not a fact that I stated to the IO that while my husband running away with fear towards FCI road, he fell down quarter number 1. It is not a fact that my husband has not sustained bleeding injury at the GI pipe assault of acute Gokula. It is not a fact that the hand of acute the Gokula was the hand of the acute Gokula hand of my husband near quarter number 1 when he fell down and sustained the bleeding injury on his head. It is not fact that the injury of the backside of my son was due to by coming in contact with the branches of trees, but not due to the assault by means of the GI pipe of the accused. It is not a fact that for our previous grudge we have foisted false case against the accused. The doctor,
He was not examined.
doctor,
It was sir ଲେଖିଛନ୍ତି ଦି ଜଣ ଯାକ କିଛି objection କଲେନି ସେଥିପାଇଁ it was yes your lordship. Again. Exhibit 12.
Keystone in 3 speeches. Keystone, feature the original products. The numbers to star. I usually produce them the back of the here or an area that which are available with this. We have to get by third party of this all. That's why but you know and bullshit. And getting money. Is who are the other witnesses?
Doctor your lordship.
12 is a witness. Eyewitness.
The that has been taken by the witness that he was also assaulted, this accused.
Yes, right.
तार किसी इंजरी रिपोर्ट
Listen.
ईमेल से और पसला वीडियो आएगा
नहीं सेमती किसी
suggestion and
by the cross examination.
these 13 statements that they have taken it for their come to the 330. The 13 statement after the question of the parties, they are in public. Whatever you want to say in your defense. File the page number of people.
ଘଟଣା ରାତି 10ଟା ସମୟରେ ମୁଁ ଖାଇ ବସିଥିଲି।
I was
ବିଭୂତି ମୋ ଘରକୁ ପଶିଯାଇ ମୁଁ କାହିଁକି ଜୋରରେ ଟେପ୍ ରେକର୍ଡର ବନ୍ଦ କହି ବଜଉତି କହି ମତେ ଗୋଟେ ଚାପୁଡା ମାରିଲା ଓ ମୋର 2 ହାତକୁ ଧରି ଘୋଷାଡି 1 ନମ୍ବର କ୍ୱାର୍ଟର ଆଡକୁ ନେଇ ଯାଉଥିବା ସମୟରେ ସେ ମୋ ହଁ ଖସିବା ସେ ଗୋଟେ ଭାଙ୍ଗି ପଡିଥିବା ଗଛ ଖୁଣ୍ଟି ଉପରେ ପଡିବାରୁ ତାର ମୁଣ୍ଡ ପଥରରେ
ପିଟି
ହେଇଗଲା, ରକ୍ତ ବୋହିଲା। ତାକୁ ଛାଟି କରିକି ମୋ କ୍ୱାର୍ଟରକୁ ପଳେଇ ଆସିଲି। ମୁଁ
ଗଛ ପଡିଥିଲା, ଗଛରେ ମୋ ବ୍ୟାଗ ହେଇଗଲା। That is also suggested to these weaknesses. So any injury report, I think why we are asking the performance of the car is done. Medical officer of that the customer similar. Freedom to 9.
Deceased, your lordship.
Both were treated to
He law branch treatment
एक्सपायर 4 दिन पर एक्सपायर
ତାପରେ ଯୋଉ 2 ନମ୍ବର ଏଇ ଯୋଉ ଡିସିଜ ପ୍ରୋସେସ ଦେଖୁଛି ଗୋଟେ ଭୁଇସ ରହୁଛି ଯୋଉଟା କି ସିମ୍ପଲ କହୁଛି ସେଟା ହଉଛି ଲାସରେଟ ଗୋଟେ ରହିଛି ଲେଫ୍ଟ ସାଇଡ ଉପରେ ସେଟା ବି ସିମ୍ପଲ କହୁଛି ଆଉ ଗୋଟେ ଲାସରେଟ ରହୁଛି parietal region simple multiple fracture of left parietal it is serious and blood patient was referred to the neurosurgery department of the civil medical college on 5/11/17 हमने ये घटना करी थी 4/11/5 में पट्टेला मौला चीज में
No.
रे
और बाकी ये ना एक नंबर तक 3 नंबर तक की और ये जो चला number second
hostile
number second
hostile Panchanabdi hostile neighbor also wala hostile
investigation daily की हो रही है आप इधर सब
आर्टिकल 17 made over the investigation charge to wise ये मंगला बीपीएस सूट inquest माने brother of the deceased बारह डॉक्टर 13 आयु prosecution
ତାପରେ ଚେଞ୍ଜ କରିକି ବିପଦରେ ଡ୍ରାଗ କଲା ପରେ ତାକୁ ସ୍ଲିପ୍ କରିଦେବା ସ୍ଲିପ୍ କଲା ବେଳକୁ ନା ସେଠି ଗୋଟେ ଗଛ ପଟା ଗଛ exactly there. But the injury sustained as reported, but the story created by the procedure. Injury is also see part ये ट्रायल को डिस्कशन करते हो management में the teaching speed and you can see the slip for the
এটা পারা 14 লিখেছে। ପାରା 14 ପେପର ବୁକ୍ ର ପେଜ ନମ୍ବର 18 ରେ
18 last for 5 line. 12 line. But no evidence was elicited from the
Therefore,
doctor.
PW1 is a competent person to give his opinion about the cause of injury head of the deceased if made otherwise than assault by means of GI code. But no evidence elicited from the doctor PW1 by the defense if he find any foreign substance like the dust or stone particles from the place of injury before the same was stitched by him, so as to hold that injury was caused by stone. The doctor has not stated any. I have not seen any foreign substance like dust particles or stone substance in the said place of injury on the head. None of the witnesses have stated to have seen blood stain either on the stone lying on the spot or any branches of the tree. In the such premises, it cannot be said that hand injury of the
Para 15 also there.
So return you are considered only disability.
disability.
Para page 21 for internal tool. Page 18. 18 a detailed discussion as
Keeping the settled law in view, it is now required to see how far the son, wife, and the daughter and their daughter are truthful in their
12.
version.
No.
I will. But your lordship, just one point, your lordship, 313 statement रे ତା daughter ଆଉ wife विषय किछि पचारेनी accused को. The deceased is my father. On the date of occurrence, the accused Gokula was staying in quarter number 6. The occurrence took place on 4/11/1997 at about 10 p.m. in the night, and I was reading in class VIL. Then 7.
I went to my bed after taking my meal. My father was outside of the house to stop the tape recorder sound coming from quarter number 6 of accused Gokula. There was a quarrel. Gokula and my father, when my father repented and asked him not to operate the tape recorder, causing disturbance in the sleeping the neighborhood. Hearing this quarrel, I came out uh, with my brother and mother.
No. Again.
In the midst of the quarrel, the accused went inside the house and returned with a GI pipe. And for fear of assault, my father started running towards FCI Road, but fall down on the way near quarter number 1. After which, the accused gave 2 to 3 blows on the head of my father by means of the GI pipe, causing severe injuries. Then my brother went to rescue my father, and he was assaulted by the GI pipe. And thereafter, the accused returned to his house with the said pipe. My mother tied a place of injury of my father in a frock of mine. Thereafter, my mother brought an ambulance by making requisition over phone, in which my father was taken to FCA hospital. My father was kept uh, treat- treatment till next day in the FCA hospital, and at the advice of the doctor, my father was removed to SCV Medical College Kotak, and 4 days thereafter, he died under treatment. My father never takes liquor. It is a fact that I stated to the IO about 9 a.m. I, along with my brother, went to the bed. It is not a fact that I have no knowledge about this occurrence, as I have already slept prior to the time of occurrence. It is not a fact that I woke up from the sleep when my father was brought to my house from the place of occurrence. It is not a fact that accused Gokula has not assaulted my father in the GI pipe, as he mm, mm, stated is false. It is not a fact that my brother was not assaulted by the accused. It is not a fact that I deposed falsehood in the instance of my brother and mother.
You found she would carry us out of the cage. And all you need
PW8.
PW7.
PW8 হচ্ছে মঙ্গলাবার।
PW7.
PW7. PW7. 654. Part. Initial FIR lodge. 8-11 पर्यंत ही আছে।
Usually, I think I was a studio. Really translated.
Keeping in the settled rule of law, in view of it is now required to be seen how far the son, wife, and the daughter are truthful in their version.
Yes.
In view of the defense case, the deceased has come to his house, gave him a slap, dragged him to the place of occurrence from his house, where he fell down accidentally and sustained the injuries on his head. PW9 is the son of the deceased, 19 years boy. He has categorically stated that his father returned to the quarter at 10:15 p.m. after taking his meal. While he was about to go to his bed, heard that the accused Gokula Samal plays the tape recorder in loud voice, thereby causing disturbance in their sleeping and in their children's study. Thereafter, he went to the accused and asked him to slow the sound. It is further stated by him that prior to the date of occurrence, his father also warned the accused several times not to play the tape recorder in high sound and not to waste drinking water by opening the tap of the in his house, thereby causing demo, diminution of water flow to his house. At the time of occurrence, issued a there ensued a quarrel between the father and the accused in front of the house of the accused. During the quarrel, he himself, his mother, and sister came outside of the quarter, and they saw, midst of the quarreling, the accused entered inside his house and again come out holding a GI pipe in his hand and chased his father to assault. Out of fear, the father started running towards the quarter number one. The accused who was chasing him holding the GI pipe dealt a blow by the said GI pipe to the head of his father, which hit him about the left eyebrow. uh, uh, his father fell down. Thereafter, the accused gave three blows by means of GI pipe on the head of the father. When he went to rescue his father, the accused dealt two successive blows by the GI pipe on his backside, neck, and back, for which he fell down, and the accused ran away to his house with that GI pipe. Thereafter, his mother and neighbors came to the spot, and with their help, he took the injured father to his house. A frock of his sister was tied in his head to check the bleeding of his father. Thereafter, in the meanwhile, his mother contacted FCI hospital for ambulance over phone, and reaching the ambulance, his father was shifted to FCI hospital where he first a treatment was given. Since his native village is nearly the FCI, leaving the injured father in the hospital, went to his uncle's and brought him to the hospital. In the said night, the father was removed to SCU Medical College Hospital, Cotton, as per the advice of FCA doctor. His mother, PW10, who has corroborated the testimony of PW9, saying that his husband went to the house of the accused and objected to the high sound of the tape recorder, for which quarrel took place between him and the accused. Hearing the quarrel, she came out of the house and saw the accused entered into the house and suddenly returned with a GI pipe, chased his husband and assaulted to the.
That is the finding in.
Last night, last paragraph to 19A, similar is the evidence of PW, the minor brother of the accident. Last time, paragraph 74. On perusal.
On perusal of the evidence, these three witnesses, their evidence found to have not left any stone unturned so far the actual occurrence is concerned. The evidence of PW 9, 10, and 12 clearly established that the deceased was given 3 to 4 blows on his head by means of GI pipe. The oral evidence of these three witnesses remain corroborated with Exhibit 2, the injury report, as well as the observation made by the doctor during PM examination. The medical evidence and the oral evidence is found well corroborated without any variation between them, and out of all injuries, it is opined by the doctor PW1 that the head injury above the left ear on the parietal bone is fracture wound. Similarly, the doctor who conducted PM examination has candidly stated that all the injuries are antemortem in nature and death was by due to coma resulting from aforesaid craniocerebral injury and caused by blunt trauma. So the medical evidences, when read with evidence of eyewitnesses PW 9, 10, 12, it is clearly established that due to several successive blows given by the head of the injuries, the vital part of the body by means of GI pipe, a hard and blunt weapon, the deceased come to coma at a coma stage and ultimately died at SCU Medical College Hospital, Cuttack, 3 days after the occurrence while under treatment. The doctor has also opined that the above injuries are fatal in ordinary course of nature, as it appears the nature of assault and injury had come within the definition of third clause of section 300 IPC, where the accused intentionally caused bodily injury on the head of the injured, while which is sufficiently in ordinary course of nature to cause death. Therefore, it is held that the accused is committed an offense murder of the deceased Vibhuti Hota. So, taking into consideration both legal and factual aspect of this case, it is held that the prosecution has been able to prove the offense of murder against the accused beyond any reasonable doubt.
DW1 को para 2
DW1.
DW pro করে তার ফাইন্ডিং দিয়েছেন যে he was submitted the DW1 cited as a witness for the prosecution in the charge sheet, also summoned by the court to the give evidence. He was not examined in the court by the prosecution since he was declined to be examined in the court by the APP. Admitted prosecution. He was examined with 161 record month. Right, tell that. Witness appeared in the affair and he was examined with the IO, but his evidence is withheld from the court without any justifiable explanation. A serious doubt is created on the fairness of the trial. That's further submitted by non-exemption delivered by the prosecution has created adverse influence against the prosecution case. This argument around counsel defense is not acceptable under the circumstances of the case that all the neighbors occupying the adjoining quarters have not supported the prosecution for the reason known to them. The readable owner is none but one of them who was staying in quarter number 3, along with an Kishore Sahu. It is the law reported such and such. It is not the incumbent upon the prosecution to examine each and every witness so as to multiple witnesses burden the record. There are no infirmities. Infirmities were noticed in the evidence of the eyewitnesses P 9, 10, and 12, so as to seek uh, for any further corroboration the remaining witnesses of the case. Therefore, non-examination D1 as prosecution witness is not adversely affected the prosecutions. So, taking into consideration the fact and evidence on record, it is found that the prosecution has able to prove the offense 302 IPC against the accused causing the death of the deceased by resulting the head by means of a GI pipe on the date of occurrence.
तो जहाँ बड़ा पूछी बड़ा का ଚାରି ଏଗାର ରାତି 10ଟା ଇଏ ବାବୁ ଯେତେବେଳେ ଆସିକିନି ଆମ ଡେଲିଭରି ଆଇଟିକିନି କହିଛନ୍ତି ଯେମିତି ରେଡିଓ ବଜାଉଛି ନହେଲେ ଟେପ୍ ବଜେଇଛନ୍ତି ଏ ଟେପ୍ ଟିକେ ବଡ ସାଉଣ୍ଡରେ ଦେଇନି ଇଏ ଆସିକିନି ପର୍ଯ୍ୟନ୍ତ ଆସି
ଘରକୁ ନ ଆଇଲେ ସାଉଣ୍ଡ ଟା ଶୁଭିବନି ତେଣୁ ଆସି ମନା
କରନ୍ତି ଏଇ ଜଣଙ୍କ ଭିତରେ ଝଗଡା ହେଇଛି ସେଇଠି ଦିଟା ଷ୍ଟୋରି ଆସୁଛି ମାନଙ୍କ ଷ୍ଟୋରି ହଉଛି ଇଏ ମତେ ଟାଇମ୍ ହେଲା ଟାଇମ୍ ହେଲା ହଠାତ୍ ତା ହାତଟା ଖସିଗଲା ସେ ପଡିଗଲା ପଡିଲା ପରେ ମୁଣ୍ଡ ବାଜିଲା ପଥରରେ ସେ ଇଏ କହୁଛନ୍ତି ନାଇଁ so there is culture of all
If say story to be accepted for the moment, when a person being dragged, there must be a opposite force. ଯଦି ହାତରୁ ଖସିଗଲା ବି ପର୍ସନ ମଧ୍ୟ ବି ପଡି ଯାଇଥାନ୍ତା ଇକ୍ୱାଲ ଆଣ୍ଡ ଅପୋଜିଟ ଆଜ୍ଞା ଡିସିପ୍ଲିନ ପାଇଲା
This treatment in the neurosurgery department that has not been proved by any law. In other quotes, the neurosurgery to refer color into medical IU एक मंगला जो आस्ती IU सेवा PW कितने चलो
8
still medical program regarding swans as well the rumors I visited the SC medical college by the question I think the question is there to function documentary evidence for other emergencies.
only treating doctor PW1 initially is initial
treatment actually human accident
wife brother and one of the medical staff
this stated that was admitted in the
yes sir
neurosurgery
yes sir no neuro
our regional safety assisi see that people that
usually 9 euros.
9
9
number 4 of the leadership Mutaha and SW the CBFC structure created number period इका अवस्था पाया है न्यूरोसर्जरी इसमें जहाँ पूरी न्यूरोसर्जरी का एंगल बैड नंबर जनरल सर्जरी
I would
sometimes it's bad fortunately instead of one thing there must be no premeditation certain fight art must have been done in a action taken on the advantage acted in a with my or the form is not relevant or it is relevant for duplication started here. The number of films caused during the occurrence is not a decisive factor, but what is important is that the occurrence must have been sudden, unpremeditated, and the offender have acted in a field of anger. Party it is not a premeditated in the party party beat a story was a full story already disbelieved
if out of anger, if it would have been the one blow.
Number of injuries, number of injuries is number sudden blow and sudden provocation city number of fear provoke କେତେଟା blow ଦେଲା that would not see a decisive factor ଯଦି କିଛି ନଥାନ୍ତା ତାହେଲେ premeditated ଏଇଟା ସେ ସିଏ ଆସି ଇଏ ରାଜା ଦେଖୁଛି ଯେ ଇଏ ଯାଇଛି ତା ଆଗରୁ
କହିବାକୁ
He came out and he was still on the guard. This man was outside. When the quarrel was intensified, went inside, came with him. So it is not that he came with the GI pipe to the house of the deceased and
with preparation.
ठीक है ना सुशील दा पार्टी करके
there is no question of
premeditation का chance नहीं ये particular करके provoke देखी এবং সেই কি অপরাধ করি নাকি কি
Also, another decision of the Honorable Supreme Court. Here, 304 Part 1. Yes, sir. ସେଠି actually ସେ period undergone କରିଦେଇଛନ୍ତି କିନ୍ତୁ କେତେ period ଟା ରହିଛି ସେଠି ଲେଖି ନାହାନ୍ତି period
ଅନ୍ୟ କିଛି point
କିଛି ଲେଖେ sudden quarrel ଆଉ 4 to 5
the consent of the district of solve the key charge for the exchange of what is apparently inflicted easily on the disease all of a sudden.
ସେଇଟା 4 to ଏଇ ଯୋଉ ପ୍ରଥମେ ଲେଖା ହେଇଛି on exchange of hot words between appellant and activity.
Hospital case during which time the appellant on the inflicted injury on the deceased of the then draw of the heart, the appellant finding on the spot.
Yes, spot that is then.
Listen. We are appeal number 97 of the problem. Describe the thought. Very additional system to start here. This conclusion of the 61 and 24.
1990. Intentionally found murder of three people practically without assist and also voluntarily of the because for affected people line. The learning trial I is based on and people given also all the charges and suggestion of the and position and sentence to one level I for 1 month and a session 323 EDC UB sentences for them. The prosecution case as well as the passing of the file even officially in charge of the prosecution. I say so that typically feels practicing the year. The people who are you are also a sort of plan PDGA, which is suspended. And after the year is gone. প্রথম আয়োটা কি হলো?
W7 version.
So Granite case with C.
On the basis of observation, submitted by PW. In the absence of the official insurance, PW7 become insolvent. If system solving statement is international sale registration or registering the from registration of the patent
1997 Committee for Investigation. During course of the investigation, he examined the employment I prepared his spot map, Exhibit 7, and he was informed that deceased in Ringo FCI hospital and they are after to further construction. Stop. PW7 command line proceeded FCI hospital. He could not examine the deceased as he was in the last stage. He issued requisition of the medical examination, correction of the stops. He ceased Austrian Arkansas the spot in prudence of the request that prepared this information. It's and the issue in the position. He also seized the very laterals of PW9 and he on 8/11/1997 he handed over the charge of distribution to PW13 of June Bari, not the officer in charge of diplomacy. PW13 after taking over the charge of distribution visited this spot and that case to be registered under section 320 he received the news on 9/1/1997 from the date of the deceased and according to the case called under section 30253C that it was implemented and SDZ chain. The IAC, ये मंगलवार के खाना
Shatpati. Virupaksha Shatpati. Virupaksha Shatpati. Signature to Tale.
ASI attached to Mangalabad police station on receipt of casualty memo from SCB Medical College Hospital regarding the death of the deceased. Registered Mangalabad PS UD case number 681 of 1997 and the IAC directed him to take up inquiry. Stop. During UD case inquiry, he visited the SCB Medical College, held inquest over the dead body of the deceased in neurosurgery ward and prepared the inquest report exhibit 9 and also the dead body challan exhibit 10 and dispatched the dead body for postmortem examination and he also received the postmortem report and sent the same to the IU bracket PW13 and closed the UD case. Stop.
The appellant surrendered at the police station on 12/11/1997, and he was arrested by PW13, and on the information given by the appellant regarding concealment of the GI pipe under a bush on the back of his quarter, the statement was reduced into writing, and the appellant led the police party and the witnesses and gave recovery of the GI pipe bracketary MO1. And accordingly, the same was seized under seizure list, exhibit 6/2, 5/2. 5/2. Stop. The IO bracketary PW13 forwarded the appellant to court and also made a query to the medical officer of FCI hospital regarding the possibility of the injury sustained by the deceased, where he was first treated, and accordingly received positive opinion from the doctor. The IU also took steps in producing the exhibits before the learned SDGM for its dispatch to SFSL for chemical examination, and accordingly received the report, chemical examination report. Stop. He collected the case diary, PM report, inquest report, dead body challenge, command certificate, etc. from Mangalabad police station in connection with Mangalabad PSUD case number 681 dated 8/11/1997, and also we obtained the injury report of PW9 from the medical officer FCI hospital, and on completion of investigation, he submitted charge sheet against the appellant under section 302 P25 of the Indian Penal Code from 6/2/1998. After submission of charge sheet, the case was committed to the Court of Session, where the London Trial Court in the charges as apportioned, since the appellant refuted the charges and claimed to be tried, the sessions trial procedure was resorted to establish his guilt. In order to prove its case, the prosecution examined 13 witnesses. The prosecution also exhibited 14 documents. The prosecution also proved 6 numbers of material objects. The London Trial Court the defense plea of the appellant in short is that on the date of occurrence, while the appellant was in his house, in his quarters, the deceased came and entered inside the quarters of the appellant and started quarreling with him as uh, accusing that the appellant was disturbing uh, them uh, in tuning the tape recorder in a loud voice. Uh, and thereafter, the deceased dragged the appellant, holding his hands to outside of his quarters and dragged him towards quarter number one. And while so dragging, the deceased came in contact with a big stone and fell over it, as a result of which he sustained bleeding injury on his forehead and a tree was also lying at that place to the side of the road and the uh, the defense, the appellant specifically denied the that he had assaulted the deceased uh, on the at the time of occurrence, on the date and time of stop. The London trial court, the one witness was examined on behalf of the uh, defense in support of the defense. The London trial court, after assessing the evidence on record, came to hold that the deceased has died a homicidal death and the London trial court disbelieved the defense story that deceased sustained the injuries on his head by coming in contact with any stone or branches of a tree. Stop. The London trial court relied upon the evidence of three eyewitnesses, that is PW 9, 10, and PW 12, who are the son, wife, and the daughter of the deceased, respectively. And found their evidence who have clearly established that the appellant is the author of the crime and has dealt blows on the head of the deceased by means of a GI file. The London trial court further held that the evidence of these three eyewitnesses gets ample corroboration from the medical evidence and accordingly held the appellant guilty under section 302 for causing the death of the deceased and also under section 323 of the IPC for assaulting PW9. Stop. The your good name, Mr. Kahan Sankar. আপনার নাম কি লিখে দিয়েছেন Mr. D.P. Bhallan, senior advocate, being ably assisted by so and so, submitted that the London trial court should not have placed implicit reliance on the three eyewitnesses who are related to the deceased, and there is every chance of false implication of the appellant. It is further argued that the defense has taken a specific plea and examined one witness, and the defense plea appears to be a probable one, and the London trial court has not assessed the defense evidence properly and rejected the defense plea. It was further argued that from the evidence on record, it is apparent that on the date of occurrence, while the appellant was playing his tape recorder in his quarters, it was the deceased who went to the house of the appellant and objected to playing the tape recorder loudly, for which a quarrel ensued between the two. And during course of such quarrel, the appellant stated to have dealt some blows on the deceased, and therefore, since it appears that the occurrence has been sudden and unpremeditated, and the appellant acted in a fit of anger, the conviction under Section 302 IPC is not sustainable in the eye of law, and it may at best be a case under Section culpable homicide not amounting to murder under Section 304 Part 1 of the Indian Penal Code. Reliance has been placed in two decisions of the Honorable Supreme Court in case of Surinder Kumar versus Union Territory Chandigarh, reported in 1989 to Supreme Court cases 217, and Subhas Gangadhar Jadhav versus State of Maharashtra 2019, 16 SCC 7 to 8.
May I pray another judgment by your lordship?
So also the so also in the case of Hikaram Bagh versus State of Odisha, case reported in 2015 61 Odisha Criminal Reports 810. Mr. Aurobindo Mohanty Lanan, Additional Standing Counsel, on the other hand, supported the impugned judgment and contended that mere relationship is not a ground to disbelieve the evidence of the three eyewitnesses whose presence at the place of occurrence, which is adjacent to their house at the time of occurrence, cannot be doubted. And the three witnesses have specifically stated as to how the appellant assaulted the deceased with GI5 on the head, and their evidence is getting corroboration from the doctor bracketry PW 7 PW1, who was attached to the Talcher FCI hospital as the medical officer. So also from the evidence of the doctor bracketry PW PM doctor here.
PM doctor was not examined.
Acha. So also from the postmortem report bracket exhibit 12, which has been marked an admission. The Learned Council submits that the Learned Trial Court has rightly disbelieved the evidence of the defense witnesses, defense DW1, who was in fact a prosecution witness, and the prosecution thought it in not to examine, and the Learned Trial Court has also rightly disbelieved the defense plea. It is argued that in view of the nature of injuries uh, caused to the deceased by the appellant with a GI5 on the vital part of the body like head, uh, it is apparent that the petitioner, the appellant, intended to commit the murder of the deceased. And in fact, the deceased, after his after the assault, became senseless and went in a coma, and he was admitted in the neurosurgery department of the SCB Medical College. And while undergoing treatment, he expired on 9th of 9th of November 1997. Therefore, there is no infirmity in the imperial judgment, and the criminal appeal liable to be dismissed. Stop. Uh, Before proceeding to the assess the evidence of the three eyewitnesses, so also the defense plea, let us first examine the materials on record as to whether the defense, the prosecution has successfully established that the deceased met a homicidal death or not. Apart from the deceased was first examined by PW1 in Talcher FCI hospital by PW1, and he noticed the following injuries. The doctor has referred the deceased to neurosurgery department of SCB Medical College, Kamakata. Of course, the doctor who treated the deceased at neurosurgery department has not been examined, nor any document of the bed ticket of the neurosurgery department has not been proved in the case, but the Mangalabag Thana but PW8, ASI of Vidanasi police station, on receiving the memo from the casualty memo from the SCB Medical College Hospital, proceeded regarding the death of the deceased, registered the Mangalabag PS case number 681 of 1997, and on being directed by the IAC, took up the inquiry, and during indication inquiry, he visited the SCB Medical College Hospital and found the deceased was in neurosurgery ward, and his bed number is inquest hour bed number 2 inquest house exhibit कहते हैं the bed number is 13. Bed number is 13, and he prepared the inquest report exhibit 9. Stop. He also sent the dead body for post-mortem examination, and the post-mortem report has been marked on admission as Exhibit 12, which indicates that the deceased has sustained the following injuries. The doctor has opined like this, and the cause of death is this, antemortem injury hisebulectomy. The learned trial court, relying upon the evidence the postmortem report finding, has held the death of the deceased to be homicidal one. The learned counsel for the appellant has not disputed about the homicidal death of the deceased. Therefore, on the basis of the evidence of the doctor PW1, PW8, and comma the inquest report exhibit
Nine.
exhibit 9, so also the postmortem report exhibit 12, which was marked on admission. We are of the view that the learned trial has rightly came to the conclusion that the deceased met with a homicidal death. Stop. Coming to the evidence of the three eyewitnesses, that is PW9, PW10, and PW12, it is not in dispute that they are the son, widow, and the daughter of the deceased. The contention of the land council for the appellant that the evidence of these three witnesses should not be accepted in view of their relationship with the deceased is not acceptable, in as much as mere fact of relationship is not a ground to disbelieve the evidence of the related witnesses, are as they are not likely to spare the real culprits and implicate somebody falsely. In view of the settled position of law, that the version of the related witnesses can be accepted if it refuses confidence, we are not inclined to reject their testimony on the ground of their relationship with the deceased. PW9 Saparapelli is the informant in this case, who is also an NGO and eyewitness to the occurrence. He has specifically stated that on the date of occurrence, his father returned from his duty to their quarter, which is quarter number 7, at 10:15 p.m. And the appellant was staying in quarter number 6. After taking milk, when the deceased was going to his bed, he heard the appellant switch on the tape recorder, and it was loudly sounding, causing disturbance. And accordingly, the deceased asked the appellant to slow the sound of the tape recorder. PW9 further stated that prior to the occurrence date also, on some occasion, the deceased had warned the appellant not to create a sound, a loud sound, by playing tape recorder. He stated that there was a quarrel ensued between the appellant and the deceased over this issue, and he came out of the house, so also his mother bracket PW 10 and sister bracket PW 12. He further stated that during such quarrel, the appellant suddenly entered inside the house, brought a GI5 and chased the deceased to assault. The deceased ran away towards quarter number one, and near quarter number one, the appellant dealt a blow by a GI5 on the head of the deceased, which hit over the left eye broke, as a result of which the deceased fell down. And thereafter, the appellant gave 2 to 3 blows by means of that GI5 on the head of the deceased. When PW9 went to the rescue of the deceased, the appellant dealt 2 blows to him also by that GI5, for which PW9 also fell. And after the appellant uh, went to his house with the GI5. PW9 further stated that some neighbors arrived at the spot, and at that time there was bleeding from the head of the deceased, and a frock of PW12 was tied in the wound, and the ambulance was called for from FCI hospital, and the deceased was taken to the hospital by PW10 and PW12. PW9 also accompanied them to the hospital, but after uh, since and he came to his paternal uncle's house and called him to the hospital, and he could not lodge the FIR in the night of occurrence, and lodged the FIR on the next day at about 9 a.m. He further stated that the deceased was in a coma state, removed to Qatar, and he remained in the quarter with his sister bracket PW12, and subsequently came to know that the deceased died after 4 days of treatment in the neurosurgery ward of SCG Medical College Hospital. In the cross-examination, it has been elicited that the appellant was not putting on well with them even prior to the occurrence, on the ground of on account of operating the tape recorder in a loud voice. PW9 has stated that he saw the quarrel between the appellant and the deceased standing on his own veranda, and the deceased was standing in front of the house of the appellant, and the appellant was standing on his own veranda at the time of quarrel. though the defense plea has been suggested to this witness, but he has denied that uh, the appellant, that the deceased sustained the injuries while he was dragging the hand of the appellant uh, and trying to pull away. And the appellant was trying to pull away from the hand of the deceased, for which the deceased slipped away and fell on a stone near quarter number 1. Nothing has been elicited in the cross examination further to doubt the credibility of PW9, whose presence at the scene of occurrence, being an injured witness who has been treated by PW1, cannot be doubted. It is pertinent to note that PW1 being examined by PW1 PW9 being examined, 9 being examined by PW1 at the FCA hospital, found to have sustained the following injuries. One, stop. The evidence of the doctor is the postmortem report also corroborates the version of the PW9. The next eyewitness is PW10, the widow of the deceased, who has stated that on the date of occurrence, prior to the occurrence, the deceased was quarreling with the appellant by giving him caution not to operate the tape recorder with a loud sound, which was causing disturbance in the study of the children. And also, he should not keep the gutter tap open as the water was being drained out. She further stated that at the time of occurrence, her husband, deceased, went and objected to the appellant for operating the tape recorder in high sound. And when there was a quarrel, she came outside of the quarter. She further stated that in the midst of the quarrel, the appellant went inside the house and returned with a GI pipe and assaulted on the head of the deceased by chasing him. And when PW9 went to the rescue of the deceased, the appellant also assaulted him with the said GI pipe. She further stated that she shifted her husband, deceased, an ambulance to the hospital, FCI hospital, with her daughter, PW 12. She stated that the deceased was then taken to Qatar for treatment, and during course of treatment, the deceased expired. And she also identified the GI pipe with which the deceased and PW9 were assaulted by the appellant. In the cross examinations, he stated that PW9 first came out of the house hearing the quarrel between the deceased and the appellant. Like PW9, the defense plea has also been suggested to the PW10 that the husband fell down on a stone while dragging the appellant, but the same has been denied by PW9, sorry, PW10. Therefore, the evidence of PW10 has remained unassailed and it corroborates the evidence of PW9. The daughter of the deceased has been examined as PW9 and she also corroborates the evidence of both PW 9 and 10 and specifically stated that the appellant dealt blows by GI5 on 2 to 3 blows on by GI5 on the head of the deceased, causing severe injuries, and nothing has been elicited in the cross-examination except giving some suggestion. Therefore, we are of the view that the evidence of the three eyewitnesses, that is PW9, PW10, and PW12, are consistent and they corroborate each other, and their evidence is also getting corroboration not only from the medical evidence adduced by PW1, but also the post-mortem report finding as per Exhibit 12. And the Lennon trial court has rightly placed reliance on the evidence of these three witnesses. And the evidence on record further indicates that after receiving the assault at the spot, the deceased was shifted first to FCI Hospital, Talcher, from where, as per the suggestion of the doctor PW1, she was taken to the SCB Medical College Hospital, Qatar, and admitted in the neurosurgery ward, where during course of treatment he expired on 9th of November 1997. In view of this evidence on record, there cannot be any doubt that it was on account of the assault made by the appellant with the GI5 bracket with MO1, the death of the deceased had taken place. Stop. Now coming to the sequence of event and the manner in which the occurrence has taken place, we found that on the occurrence night, while the deceased, while the appellant was playing tape recorder in causing loud sound, it was the deceased who came near the house of the appellant and objected to him for playing the tape recorder in such manner. That for that reason, a quarrel ensued between the two, and during course of such quarrel, the appellant assaulted the deceased. In the case of Surinder uh, Kumar versus Union Territory Chandigarh, while considering the exception 4 to Section 300 of the Indian Penal Code, the Honorable Court has held that to invoke the exception, four requirements must be satisfied, namely, Roman 1, it was a sudden fight. Roman 2, there was no premeditation. Roman 3, the act was done in a heat of passion. And Roman 4, the assailant had not taken any undue advantage or acted in a cruel manner. It is further held that the cause of the quarrel is not relevant, nor it is relevant who offered the provocation or started the assault. The number of wounds caused during the occurrence is not a decisive factor, but what is important is that the occurrence must have been sudden and unpremeditated, and the offender uh, must have acted in a fit of anger. Of course, the offender must not have taken any undue advantage or acted in a cruel manner. A taking into account the factual scenario in the said case where fatal injuries were caused by the appellant during course of such quarrel, the Honorable Court altered the conviction from Section 302 IPC to Section 304 Part 1 of the Indian Penal Code. In the case of Subhas Gangadhar Yadav, the Honorable Court has that noticed that the appellant inflicted 4 to 5 injuries on the person of the deceased and the deceased died at the spot. However, the Honorable Court found that there was exchange of words between the appellant and the deceased, and all on a sudden, the appellant inflicted the injuries to the deceased, and there was no premeditation or intention on the part of the appellant to commit the murder of the deceased. Accordingly, the conviction under Section 302 IPC was altered to one under Section 304 Part 1 IPC. In the case of Tikaram Bag, the এটা কোন প্যারাগ্রাফ এটা দেখছেন নি
लास्ट पैराग्राफ प्लास्टिक टर्म लिखा है इसका
আচ্ছা this আচ্ছা in which acha, where the occurrence took place being preceded by a dorsal and the blow was inflicted by a geda. The honorable this court has altered the
para 19
para 19
last one 19
has altered the conviction under Section 302 IPC to from 302 IPC to Section 304 Part 1 IPC. In the factual scenario, we found that there was no premeditation on the part of the appellant to commit the crime. The occurrence took place all on a sudden when the deceased went to the house of the appellant and standing in front of the house, he protested to the appellant for playing the tape recorder in a loud, causing a loud sound. And thereafter, the quarrel ensued between the two, during course of which the assault took place. Therefore, the occurrence has happened suddenly in an unpremeditated manner, and it appears that the appellant has acted in a fit of anger. Therefore, we are of the view that the ratio laid down, in view of the ratio laid down by the Honorable Supreme Court in the aforesaid two decisions, uh, the conviction under Section 302 IPC in the factual scenario is not sustainable in the eye of law. Accordingly, the conviction is altered to under Section 304, Part 1 of the Indian Penal Code. When the matter was argued on the previous day, we asked the Land Council for the state to obtain instruction about the criminal antecedent, the conduct of the appellant,
Pre and
and
post pre and post conviction.
the pre and post convictions. And today, the Land Council for the state has produced the report of the IIC Vikrampur police station, which shows that the appellant is now aged about 57 years and no criminal antecedent is there against the appellant. And during interim bail, the appellant was residing in his house and he was showing good conduct with the neighbors and in the locality. And he was working as a contractual worker at smelter plant as a pump operator and was performing his duty sincerely and faithfully. Stop. It appears that the occurrence took place in the year 1997 and 28 years have passed in the meantime. The appellant was taken into custody at the first instance on 12 judicial custody, 12/11/1997, and he was granted bail during trial as per the order of this court on 2/12/1999. After the judgment was pronounced on 24/11/2000, he was again taken into judicial custody, and during pendency of the appeal, he was granted bail by this court on 15/12/2003. In view of the such period of imprisonment and the fact that the occurrence has taken place 28 years back while convicting, while altering the conviction of the appellant one under Section 304, Part 1 of the IPC, the sentence is reduced to period already undergone. Accordingly, the criminal appeal is allowed in part.
Item 3, man. Item 3, man.
Huh.
IAC Kumna.
Excellent. लोकनाथ सतना ये दुर्गा
IIC कोमना पुलिस स्टेशन
ସାର୍ ନମସ୍କାର।
ହଁ କଣ ନାଁ କଣ ଆପଣଙ୍କର?
କୁଳମଣି ଗୁରୁଦାସ।
କୁଳମଣି
गुरुदास
Gurudas.
ଗୁରୁଦାସ।
GURUDAS ଆଚ୍ଛା।
সেটা তো
ନାଇଁ ସାର୍
BURAD
URUDS।
ଓହୋ ଗୁରୁଦା କହିଲେ ଆପଣ ଗୁରୁଦାସ BURUDA
ଆଜ୍ଞା
Guruda.
ବୁରୁଦାସ କୁଳମଣି ବୁରୁଦାସ ଇଏ କଣ ହେଲା ସେ ଆସିଲା ଲୋକନାଥ
ନାଇଁ ସାର୍ ସେ ଆସିନି ସାର୍ ତା ମୋବାଇଲ ସୁଇଚ୍ ଅଫ୍ କରିଦେଇଛି ସାର୍ ତା ଘରକୁ ମଧ୍ୟ ଯାଇଥିଲେ ସାର୍ ଘରର ଲୋକ କହିଲେ ଯେ ତାର ଭାଇ ଯିଏ କହିଲେ ନାଇଁ ସାର୍ ସେ ସୁଇଚ୍ ଅଫ୍ କରିଦେଇଛି ମୋବାଇଲ ଆଉ ସେ ମଧ୍ୟ କଣ୍ଟାକ୍ଟ ହେଇପାରୁନି କହୁଛନ୍ତି
ମାନେ you have not contacted him at all.
ନାଇଁ ନାଇଁ ସକାଳେ କରିଥିଲେ ସାର୍ ମତେ କଥା ହେଇଥିଲା ସକାଳେ ମୁଁ ଡାକିଲି ତାକୁ ଆସୁଛି ବାଟରେ ଅଛି ବୋଲା ମୁଁ ଗଲି ସାର୍ ତା ପାଖରେ ଗଲା ବେଳକୁ ୱେଟିଂ ଦେଖେଇଲା ଦେନ୍ ତାପରେ ସୁଇଚ୍ ଅଫ୍ କରିଦେଇଛି ମୋବାଇଲ
ତାକୁ ଧରିକି ଆଣନ୍ତୁ ତାକୁ ଧରିକିନି ଏଠିକି ଆଣି ହାଇକୋର୍ଟରେ ପହଞ୍ଚାନ୍ତୁ
ସାର୍
ହେଲା
Sir.
ପାସିଂ ଦି ଅର୍ଡର 18 ତାରିଖ ଦିନ ତାକୁ ଆଣି ପହଞ୍ଚାନ୍ତୁ
Okay,
ଆରେଷ୍ଟ କରିବେନି ତାକୁ ଧରିକି ଆଣି ପହଞ୍ଚେଇବେ
ଖାଲି କଷ୍ଟଡିରେ ଆଣି
ଦେଖନ୍ତୁ on 11/11/2025 since nobody appeared on behalf of the appellant number 2 Loknath Satnami and the report was submitted before us that he is alive and staying in his village. We passed an order directing the IAC Pomna police station to ensure the appearance of appellant number 2 before this court through virtual mode today at 10:30 a.m. in order to ascertain from him about the engagement of the lawyer for the hearing of this criminal appeal. The matter was taken up in the first hour. IAC Pomna police station Kulamani Buruda appeared through virtual mode and stated that he has contacted the appellant number 2 over mobile phone, who was assured to reach the police station in a short while. Accordingly, the case was adjourned and it was placed after lunch. The IAC Kumna police station appeared again and stated that the appellant number 2 has not reached the police station and he has switched off the mobile. In view of such state of affair, let the IAC Kumna police station ensure the physical appearance of the appellant number 2 before this court on 18th of November 2025 at 10:30. A free copy of the order be handed over to the Land and Council for the state in course of the day. ଆମେ ଅର୍ଡର କଲୁ ଆପଣ ତାକୁ ଧରିକିନା ଆସିବେ ଆରେଷ୍ଟ କରିବେନି ତାକୁ କଷ୍ଟଡିରେ ତାକୁ ନେଇକିନା ଆସିବେ 18 ତାରିଖ ଦିନ ମଙ୍ଗଳବାର ଦିନ 10:30 ଆଣି ପହଞ୍ଚେଇବେ
ସାର୍ 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 ନମସ୍କାର
Item number 8.
paper that of India and disclosed what had ଗାଁକୁ ଆସିଲା Is this solitary evidence of that PW10?
My lord.
And as it appears, the occurrence in question took place in the intervening night of 19th and
10.
20th, right?
My lord.
And the FIR was lost on 20th,
Registered on 20th.
registered on 20th 10 1998 at 11 a.m. And police investigating officer is PW
19.
19. Acha, he says that on 1998, in the night itself, he received a telephone call from some unknown person regarding lying of a dead body with injuries in village Khalorda. And after receipt of the above message, he along with his staff proceeded to the spot. After reaching at the spot at 1:15, রাত্রি 1:15 পৌঁছিলে, PW4 submitted a written report. Acha, that was registered on
20th.
but it was presented as it appears. FIR presented. সেই রাত্রিরে প্রেজেন্ট ହେଇଛି ନା 19/10/1998 ରେ ଆଇଓ କହିବା ଅନୁଯାୟୀ 1:15 ରେ ପ୍ରେଜେଣ୍ଟ ହେଇଛି। ଆଚ୍ଛା, PW4 submitted a written report. I treated the same as written book of investigation. তারপরে examine the informant, prosecution witnesses, sent intimation to SP Cutter for sending scientific team photograph of the spot. Then he seized Luna moped, pair of sponge chapel, exhibit 9. Held inquest over the dead body, exhibit 3. Exhibit 3 that you asked, no? Exhibit 3 টা হচ্ছে সকাল 7টা হয়ে গিয়েছে। ইনকোয়েস্ট তাহলে 20/10/1996 না 98? 98 at 7 a.m. ভোর 7টা বেলা। আচ্ছা, তারপরে IOR evidence hela, I sent the dead body of the deceased for PM examination, exhibit 12 হচ্ছে dead body চালান। 12 টা বার করো। Dead body চালান, dispatch from the village 7:30, 20 তারিখ। পরে ଖାଲି ଲେଖା ହଉଛି ତା ଦେହରେ so cost, ଆଚ୍ଛା sharp cutting weapon ବୋଲି ଲେଖା ହଉଛି। dead body ଚାଲାଣ ବି ଲେଖା ହେଇଛି, inquest ବି ତ obviously ଲେଖା ହେଇଛି। କୌଣସି ଧାରୁଆ ବସ୍ତୁ ଦ୍ୱାରା। ଆଚ୍ଛା, ତାପରେ IO କହିଲେ RC ବୁକ୍ ସିଜ୍ କଲେ ଲୁନା ମୋପେଡର ଜିମ୍ମା ଦେଇଦେଲେ ସାଇଣ୍ଟିଫିକ୍ ଟିମ୍ ଆସିଲେ ସିଜର କଲେ ତାପରେ wearing blood stained apparels of the deceased after PM examination was done also. তারপরে এই যে স্টেটমেন্টটা রেকর্ড হয়েছে অন 21 তারিখ না?
21
আচ্ছা PW10 examine 21/10/1998 ଆଉ 21 ତାରିଖ ଦିନ ମଧ୍ୟ ଇଏ ଆରେଷ୍ଟ ହେଲା। ଫରୱାର୍ଡ ମଧ୍ୟ ସେଦିନ ହେଇଛି। 10 ନମ୍ବର ସାକ୍ଷୀ ଆମେ ସେଦିନ ଯୋଉ ପଢିଥିଲୁ ସେ କହୁଛି ଯେ ଘଟଣା ଦେଖିକିନି out of fear he left the place that is in paragraph number ତାପରେ 11 number paragraph ରେ କହୁଛି I was at a distance of 10 to 20 cubits away when I saw the occurrence. ତାପରେ କହୁଛି I was going in a bicycle. I left the spot, leaving the bicycle by the side of the canal. Police has not seized my cycle. On the next day, some of my family members brought the cycle from the spot where I lived. Paragraph 14 on the next day of the occurrence or any day thereafter, I did not try to inform the family members of the deceased. On 21/10/1998, I was examined by the IO at my village. Prior to the occurrence, and also police was coming to our village whenever necessary, I did not face the police out of fear after the occurrence. And before I was examined by the IO, I told about the occurrence on 21/10/1998 to my family members as well as the villagers. But this is not getting any corroboration. Nobody has stated that he has disclosed. And 19 number paragraph रे कहला accused persons did not threaten me at any time or at the time of occurrence or thereafter. So we posed a question to, and of course there are some exaggeration, it's all right. We posed a question to you, both of you, that the witness says to have seen the occurrence in the night of 19th of the 20th October 1998, and he was standing at a distance of 10 to 20 feet. He came to the spot in a cycle but left the cycle there at the spot and fled away out of fear, but in fact he was not threatened by anyone at the time of occurrence or thereafter. And he stated that he had on the next day also he did not disclose before though he stated that he disclosed before the family members and villagers, but none has stated that any such disclosure has been made. And it seems that on the date of occurrence itself, within 2 hours, the police has arrived at the village. IU was doing various things like holding inquest, sending the uh, dead body for post-mortem examination, examining the witnesses, conducting seizures of various things, and this witness has not come forward to give his statement on 20th of October 1998. So he came out on 21/10/1998 and gave a statement that I am an eyewitness to the offense. So whether in such a situation it can be said that the delayed examination of this witness or delayed disclosure before police is a factor for which the evidence is to be discarded, or in spite of the delayed disclosure will accept the evidence, otherwise his evidence is getting corroboration from the medical evidence. কারণ সে কহিলা যে accused লক্ষ্মীধর ডেল্টে ফার্স্ট দীঘা ব্লো এ দীঘা মানে কি
acute second.
ଆଚ୍ଛା ଆକ୍ୟୁଟାଲ ଦି ଜଣ ଆକ୍ୟୁଟାଲ ହେଇଛନ୍ତି ତାନି ଆଉ ଇଏ ସେମାନେ ଆକ୍ୟୁଟାଲ ହେଇଯାଇଛନ୍ତି those who have assaulted the deceased, and the appellant because that this PW10 did not support the prosecution case in that case which was subsequently tried. So we also asked you that how a witness whose conduct is this, who is not coming forward to give his statement, even though the police is available, even though he has not been threatened, but he states that he was in fear. But there is nothing on record that how his fear dispersed on 21 so that he came forward to give his statement. And the evidence he has stated that one Ujali blow was given by Lakshmidhar on the forehead, whereas the other accused persons who were acquitted, they also assaulted. Means Digga huchi first, the first kiye marla, Digga marla. Digga marla gote sword on the neck. ହେଲା ତାପରେ ସେ ପଡିଗଲା ପରେ ଏଇ ଆପେଲାଣ୍ଟ ସିଏ ମାରିଲା ଭୁଜାଲିରେ, ତାପରେ ଆଉ ଗୋଟେ ଆପେଲାଣ୍ଟ ଯିଏ ମଧ୍ୟ ଖଲାସ ହେଇଯାଇଛି ଟାନିଆ, ସିଏ ଫାର୍ସା ବ୍ଲୋ ମାରିଲା on the face. ତେଣୁ this witness has stated about 3 appellants, out of which 2 have been acquitted. So, and you see the specific overtake which he has attributed against this man, that he dealt a Bhujali blow on the forehead, that is not there in the 161 statement specifically. It has been confronted to him in paragraph number 20 that you have not stated that ଖାଲି ଆକ୍ରମଣ କହି ଯୋଉଟା କି PW19 IO ରେ paragraph number 34 ରେ ପ୍ରମାଣିତ ହେଇଛି। ତ ଗୋଟେ specific overtake ଦିଆ ହଉଛି, ଇଏ assault କଲା during trial for the first time on the forehead by means of a Bhujali. So others have been acquitted. The question is that, and there is no other corroboration. Why we also posed that day also that there is no legally the solitary statement testimony can be accepted provided that it is true trustworthy, and but when such a statement comes and the court has to see that whether there is any material corroboration to his evidence or not. आर किसी corroboration ही ନାହିଁ ବୁଝିଲେ କାରଣ ଅନ୍ୟ ସେ ଯୋଉ କହୁଛି ନା ମୁଁ ସାକ୍ଷୀ ମାନଙ୍କୁ କହିଲି ସାକ୍ଷୀ ନୁହେଁ ତ ମାନେ ଗାଁ ଲୋକଙ୍କୁ କହିଲି ଆଉ ଡିଷ୍ଟ୍ରିକ୍ଟର
family member and
members କହିଲି ସେମାନେ କେହି କହୁନାହାନ୍ତି
yes,
ତେଣୁ ସେଇ ପ୍ରତ୍ୟରେ କିଛି corroboration ନାହିଁ ବାକି ତାର ଯୋଉ କଣ୍ଡକ୍ଟଟା ରହିଯାଉଛି ଚୁପଚାପ ହେଇ ରହିଗଲା 1.5 ଦିନ ପର୍ଯ୍ୟନ୍ତ ହଠାତ୍ ଆସି ପୋଲିସ ପାଖରେ କହିଲା that is how far in view of that statement and that for the first time he is including a specific part of the body on which the appellant is stated to have assaulted and fact remains that he has implicated 3 persons. Subsequent trial of we have rejected that petition. He has stated that I have nothing, I have no idea about the occurrence. So, a type of a witness who we are asking, we have asked you that how it can be said that this witness is an absolutely reliable, kind of solitary. So, see, point I'm going to satisfy for you by following up submission. What did you?
yes, madam. First of all, as per the evidence of the PW2, that stated that I did not face the police out of fear. I did not
two.
PW10. I did not face the police out of fear. After the occurrence and before I was examined by the IU.
Food line down question.
That is the page 66 of the PW10.
I did not
face the police out of fear.
हाँ सी तो सीया ही कोई था
Yes, sir.
सीया मुझे चीफ एग्जामिनेशन ने कोई चीटा तो चीफ एग्जामिनेशन ने कहिला paragraph 4 को सुनांदी I saw the incident and I fled away from the spot out of fear. Even though the appellants have not threatened him माने किसी ताकू देखी चंदी बेली भी कथा नहीं ताकू किसी ये कर चंदी सी तार पड़ेला तेणु तार तथापि बिना थ्रेटनिंग रे तार फियर हला जोथि पई से पळे आसला स्पॉट रू पळेला किसी चैलेंज कलानी जे काई ताकू मारुचो पळे आसला सेही कारण पई मध्ये पुलिस को मध्ये डरगी जणैला जदि सेया हला जो भयटा जो थिला हठात केमती पळेला ता पर दिन जो आसी पुलिस पारे पहुंची कि स्टेटमेंट देला गां रे तो थिला फैमिली मेंबर्स को कहूसी से ता निजो अनुଯାयी निजो फैमिली मेंबर के कोरोबोरेशन नाही फैमिली मेंबर्स को कहूची विलेजर्स मानु कहूची किंतु कोनोसी विलेजर तो एटा समस्ते एवरीबॉडी वाज टू नो दैट हु इज द कल्प्रिट कारण जेते बळे एफआईआर हला एफआईआर हैज बीन लॉज्ड माने अगेंस्ट नंबर ऑफ पर्सन्स हला तेणु देयर इज नो मेंशन दैट एनी आई विटनेस इज देयर से कहूचे मु एई मानक सुनिली जो मानकर भी एक घटना विषय किसी आइडिया नहीं कारण से माने भी कहनाती आपे तांकू कहिलु बेली पीडब्ल्यू जो इन्फॉर्मर जो कहलु तेणु ओनली विटनेस आपनकर होउची स्टार विटनेस होउची पीडब्ल्यू10 तेणु पीडब्ल्यू10 जे कि आपनकर स्टार विटनेस जे कि कहूची मु एमिति भयभीत होई गेली जदी से मते थ्रेटनिंग कर नथिले मु जागा छाड़ी पळै आइली भयरे एवं सेही भयरे मु पुलिस को भी कहलिनी जदि एई भलिया स्टेटमेंट देले तार भयटा केमता नेक्स्ट दिन पळेला कोन पई पळेला आउ
in the meantime, on 20th number of the witness has been examined by the police. Thereafter, on 21st, he has disclosed before the police on the one suspension.
नहीं नहीं केवल समस्त कहूची से कहूची ताले भय जदि हेतान त काहाकू न कोई कोई ना हदा कारण once it come to the knowledge that I am an eyewitness to the occurrence and if I disclose then maybe something will happen to me that may be the reason for which he is telling that out of fear
and moreover the
यदि विलेजर को डिस्क्लोज करता ना विलेजर इमीडिएटली पुलिस को रिपोर्टेड कर दिया कोनोसी विलेजर आइदर तांका प्रीवियस स्टेटमेंट रे हो बा कोर्ट रे हो केही कहिसेंती कि जे पीडब्ल्यू10 हमको आसी कहला ता घर लोक कोंतु से डिसीज्ड বা କୌଣସି villager ହଉ leave it about the court statement previous statement ରେ ବି କେହି କହିଛନ୍ତି କି that could have been confronted and proved that yes ଇଏ ଆମକୁ ଆସିକିନି କହିଲା ତେଣୁ ଏଇ ଯୋଉ ସେ କହିଲା ତାର deceased family member ବିଷୟରେ everybody wants to know that who is that eyewitness or who is anybody direct evidence ଏଇଭଳିଆ ଲୋକଟା ଯଦି ଯାଇକିନି ତାଙ୍କର deceased family କୁ କହୁଛି ତା ନିଜ ପରିବାରରେ କହୁଛି ଏବଂ ଗାଁ ଲୋକଙ୍କୁ କହୁଛି immediately the matter would have reached the IO ଯେ କି ଗାଁରେ available ଅଛି investigation conduct କରୁଛି ସିଏ ତ ପଳେଇ ଆସିଥାନ୍ତା ଆଗେ examine କରିବାକୁ
He has not stated before the family member of the deceased miller.
no his own family members
own
and the
family
villagers
members and villagers.
ଆରେ they are co-villager ଆପଣ ଯେମିତି ଭାବୁଛନ୍ତି ଏଠି କଣ ଗୋଟେ ଜଣେ ଏଠି ରହିଛି ଆଉ ଗୋଟେ ସେମାନେ they belong to one village the murder has taken place in the and everybody police is investigating the case this man is disclosing before the villagers so that must have spread like wildfire that X Y and Z are the author of the crime and this man has seen the occurrence ତେଣୁ ଏଇ circumstance ରେ ଜଣେ ଲୋକ ପୋଲିସ ପାଖରେ ଜମାନବନ୍ଦୀ ନଦବା ଚୁପଚାପ ହେଇ ରହିଯିବା ହଠାତ୍ ଆସିକିନି ଦେଢ ଦିନ ପରେ ଦେଢ ଦିନ କାହିଁକି କୁହାଉଛି ନା ସେ ପୋଲିସ ବାବୁ ମାନେ ଆସିକିନି ରାତି ଗୋଟେ ବେଳୁ ପହଞ୍ଚିଗଲାଣି
date of occurrence that is the 36 hour and date of the registration of the FIR is within the 24 hours.
ନାଇଁ ନାଇଁ FIR ଦିଆଯାଇଛି ଦିନ ରାତି ଗୋଟେ ବେଳେ FIR ଟାକୁ ଡିସ୍ପାଚ ହେଇକିନି ପୋଲିସ ଷ୍ଟେସନ ରେଜିଷ୍ଟ୍ରେସନ କଲା ବେଳକୁ ପରେ ହେଇଯାଇଛି ସେତେବେଳକୁ 11ଟା ବେଳେ ହେଇଯାଇଛି ହେଲା
they are giving the statement from the date of the occurrence time of the occurrence that is within the 36 hours.
କିଏ
the PW 10 has given the statement and from the date of the registration within the 24 hours. That's
ଗୋଟେ ଦିନ ଗ୍ୟାପ୍ ମିଳିଲା ମାନେ ଆପଣ 20 ତାରିଖକୁ ଧରନ୍ତୁ ଆମେ ସେ ଏତେ କାଲକୁଲେସନ ରୁ ଯାଉନୁ
ରାତିଟା ବି ଛାଡ଼
ସେ ରାତିଟା ବି ଛାଡି ଦିଅନ୍ତୁ ରାତିରୁ ତ ପୋଲିସ ବାବୁ ଆସିଗଲେ ଇନଭେଷ୍ଟିଗେସନ ଅଲରେଡି ଷ୍ଟାର୍ଟ ହେଇଗଲାଣି କିନ୍ତୁ ଗୋଟେ ଦିନ ରହୁଛି ଯୋଉଠି ଅନ୍ୟମାନେ ଏକ୍ସାମିନ ହଉଛେ ନମ୍ବର ଅଫ ୱିଟନେସେସ୍ ମଧ୍ୟ ଦେଖିବେ ଗୁଡାଏ ଷ୍ଟେଟମେଣ୍ଟ ରେକର୍ଡ ହେଇଛି 20 ତାରିଖ ଇନକ୍ୱେଷ୍ଟ ବି ହେଇଛି ଡେଡ୍ ବଡି ଯାଇଛି ସିଜର ହେଇଛି ବହୁତ ଜିନିଷ 20 ତାରିଖ ହେଇଛି ତେଣୁ 20 ତାରିଖରେ ଦେଖନ୍ତୁ ସେ କେତେଟା ୱିଟନେସ୍ ଏକ୍ସାମିନ କରିଛି 1 2 3 4 5 6 7 8 9 10 11 12 13 14 15 16 17ଟା ୱିଟନେସ୍ ଏକ୍ସାମିନ କରିଛି ହେଲା of course some of them are seizure witnesses but their statement छोट statement भी record ହେଇଛି apart from doing the seizures and scientific officer भी ଆସିଛନ୍ତି visit କରିଛନ୍ତି arrival of the scientific ଏଗୁଡା ହଉଛି ସବୁ 20 ତାରିଖର କାମ ହେଲା ତେଣୁ 20 ତାରିଖ ଦିନ ଏତେ କାମ ସିଏ କରିଛି କଣ ଏଇ ଲୋକଟା ଯିଏ ଯଦି ଇନଭେଷ୍ଟିଗେଟିଂ ଅଫିସରର ନଜରରେ ଆସିଥାନ୍ତା ଯେ ଏଭଳିଆ ଗୋଟେ ୱିଟନେସ୍ ଅଛି ଯିଏ କି ପ୍ରତ୍ୟକ୍ଷଦର୍ଶୀ ତାକୁ ଛାଡିଥାନ୍ତେ କି ଯଦି ଅନ୍ୟ କନସିଷ୍ଟେଣ୍ଟ ଏଭିଡେନ୍ସ ହେଇଥାନ୍ତା ଅଲଗା ଏଠି ଏଇଭଳିଆ ଲୋକ ଯିଏକି ତା ଭର୍ସନ ଟୋଟାଲ ଚେଞ୍ଜ କରିଦଉଛି ଗୋଟେ ଜାଗାରେ କହୁଛି ମୁଁ ଇଏ ତାପରେ ଗୋଟେ ମୋ ଘଟଣା ବିଷୟରେ ଜ୍ଞାନ ହିଁ ନାହିଁ ଏଇଭଳିଆ ଲୋକ ଯୋଉଥିପାଇଁ କି ଖଲାସ ହେଇଗଲେ ମଧ୍ୟ 2 ଜଣ ଏଠି ତ 2 ଜଣ ଖଲାସ ହେଇଛନ୍ତି ଅବଶ୍ୟ ସେମାନଙ୍କ ଡାଇରେକ୍ଟ ପାର୍ଟିସିପେଣ୍ଟ ନାହିଁ ବଟ୍ 2 ଜଣ ଯୋଉମାନେ ଆସଲାଇନ୍ ଥିଲେ ସେମାନେ ବି ଖଲାସ ହେଇଗଲେ ଏଇ ଟାଇପ ର ୱିଟନେସ୍ କୁ ଆପଣ କେମିତି ସେଇ କ୍ୟାଟାଗୋରୀକୁ ନେବେ ଆବସଲ୍ୟୁଟଲି ରିଲାଏବଲ
and moreover my lord the accused Titu Alice Deepak Mahath and Tonia Burda that 300 to 400 feet away from the house of that PW 10.
No, what do you want to say by that?
So though there is the same locality and same villagers and labor of that PW10. They out of fear, that's why she's saying that out of fear ମୁଁ ପଳେଇ ଆସିଲି ଏବଂ ପୋଲିସ ଏଫଆଇଆର ରେ ମଧ୍ୟ ମୁଁ କହିନି ଯେହେତୁ ସେଇ ଗାଁ ପାଖର nearest Odisha, on that he has kept silence on 1.5 day. Thereafter he disclosed number of the person 20th there are 10 to 17.
ସିଏ ସିନା କହୁଛି ମୁଁ ଡିସକ୍ଲୋଜ କଲି, କାହାକୁ ଡିସକ୍ଲୋଜ କଲା ସେମାନେ ତ କେହି କହୁନାହାନ୍ତି ଆମ ପାଖରେ ଡିସକ୍ଲୋଜ କରି। ଆପଣ ଯେମିତି ଧରି ନଉଛନ୍ତି, ସିଏ କହିଲା ବେଲି ଯାହା କହିଲା ବେଦର ଗାର, ସିଏ କହୁଛି ମୁଁ ମୋ ଫ୍ୟାମିଲିରେ ଡିସକ୍ଲୋଜ କଲି ବା ମୋର ଗାଁ ଲୋକଙ୍କୁ ଡିସକ୍ଲୋଜର କଲି। ହେଲା, ଯୋଉମାନଙ୍କ ପାଖରୁ ଡିସକ୍ଲୋଜର କଲା ସିଏ କହୁଛି ତାଙ୍କ ଭିତରୁ ଜଣେ ବି କେହି ତାଙ୍କର ପ୍ରିଭିୟସ ଷ୍ଟେଟମେଣ୍ଟରେ ହଉ ବା କୋର୍ଟରେ ହଉ କେହି ଗୋଟେ ହେଲେ କହିଛନ୍ତି କି ଯେ ହଁ ଏ ଲୋକଟା ଡିସକ୍ଲୋଜ କଲା ଆମକୁ ଅପରାଧ
କହିଛନ୍ତି ଆଉ ହଷ୍ଟେଲ ହେଇଛନ୍ତି କି?
ହଁ
ଦେଖିଛନ୍ତି ଆଉ ଦେଖିନାହାନ୍ତି ଆଉ how we prepare if at all they have said and the witnesses have turned hostile also, that is different. Where is that? ଆପଣ ସେଟା ଦେଖିନାହାନ୍ତି, ହଷ୍ଟେଲରେ ଛାଡ଼ିଦେବେ ଏମିତି ହେଲା ହବ। You have to prepare irrespective of the fact if the witnesses have turned hostile, no matter.
Yes, one that I know the person Kumar Behra. From there, I had met the person after the occurrence. Person had never told me about the occurrence.
ଆପଣ ବୁଝୁନାହାନ୍ତି, still you have not got us probably. A witness may turn hostile. Have you gone through their 161 statement which they did not state before the court and was turned hostile? ଦେଖିଲେ କି କୌଣସି ୱିଟନେସ୍ ଆଗେ କହିଛନ୍ତି କି ତାଙ୍କର ପ୍ରିଭିୟସ୍ ଷ୍ଟେଟମେଣ୍ଟରେ ଯାହା ସାର୍ କହିଲେ, did you verify that any of the witnesses have stated that PW10 has disclosed before them that he saw the incident and out of fear he left the spot and is in his house? କେହି କହିଛନ୍ତି କି 161 ରେ କେହି କହିଛନ୍ତି? ଦେଖିଲେ ନାଇଁ, we are posing questions only to make you aware that these are the areas where you have to prepare yourself. We are not posing question ultimately to reach that.
We have kept open mind.
Yes.
We are posing questions to both of you that ଆପଣ ଆମକୁ ଇଏ କରନ୍ତୁ, ସେଇଥିପାଇଁ କେସଟା ଆଡଜର୍ନ ହେଇକି ଆଜି ରହେ। Rest depends upon your preparation.
ଏବେ ପଢିଲେ ହବ ନାହିଁ ପ୍ରଧାନ ସାର୍, ଏବେ ପଢିଲେ ହବ? It requires preparation of a brief altogether. You have to find out where the statement is there, how far the statement is believable, why the credibility of the witness will not be challenged that way, and as such they were turned hostile. Number of witnesses have turned hostile. All right, so we are not on that. ଏଇ ଯୋଉ ୱିଟନେସ୍ ର ଯୋଉଟାକୁ ଗୋଟିଏକୁ ଆପଣ ଧରିଛନ୍ତି, ସେଇ ଗୋଟିଏର ୱିଟନେସ୍ ଟା credible, truthful, his as the defense has channel, his presence was not there at this spot where he is telling. So your argument should be that no, his presence cannot be disputed because of this reason, because of this evidence.
ଏଇଥିପାଇଁ କହୁଛନ୍ତି ଯୋଉ ୱିଟନେସ୍ ଟା କହୁଛି ମୁଁ ସାଇକେଲ ଛାଡି ଦେଇ ପଳେଇ ଆଇଲି, ଆଇଓ ତ ଆସିଲା ସ୍ପଟରେ, ଆଇଓ ଯଦି ଛାଡି ଦେଇ ଆଇଲା ସ୍ପଟରେ ସାଇକେଲଟା ସିଜ୍ କରିପାରିଥାନ୍ତା, ସିଜ୍ କରିନି ଯେହେତୁ ତା ପ୍ରେଜେନ୍ସ ଆଟ୍ ଦି ସିନ୍ ଅଫ୍ ଦି ଅକରେନ୍ସ ଇଜ ଡାଉଟଫୁଲ, ବଟ୍ ଏଭିଡେନ୍ସରେ ବାହାର କରିକି ଆଣିଛନ୍ତି କ୍ରସ୍ ଏକ୍ସାମିନେସନରେ, ସେ ନିଜେ ଲୋକଙ୍କୁ ପଠେଇଲା ରିମୁଭ୍ କଲା। That is one aspect. It's one. So cycle seizure ଉପରେ ଏତେ ଇମ୍ପୋର୍ଟାଣ୍ଟ ଦଉନୁ, ବଟ୍ ଅଦରୱାଇଜ ଯୋଉ ଜିନିଷ ଗୁଡାକ ରହୁଛି, କାରଣ ଆପଣ related disclosure ହେଲା ବା delayed disclosure ପାଖରେ ଆପଣ ମାନେ ଡିସିସନ ଏପଟରୁ ବି ପାଇବେ ସେପଟରୁ ବି ପାଇବେ।
ଯେ ନାଇଁ ଯଦି explanation ଯୋଉଟା ଦେଇଛି ସେଟା acceptable ହବ ତାହେଲେ court merely because the witnesses have disclosed or the witness has been examined after some days, it cannot be a ground to discard his evidence. But everything depends on the factual aspect. Fact ଉପରେ depend କରିବ କୌଣସି decision ଟା ଗୋଟେ ରେସିଓଟା ଗୋଟେ ୟୁନିଫର୍ମ ନୁହେଁ ଯେ ଏତିକି ଘଣ୍ଟା ପରେ ଗୋଟେ ୱିଟନେସ୍ କୁ ଏକ୍ସାମିନ କରିବ ଆଇ ୱିଟନେସ୍ ନହେଲେ ତାକୁ ଆମେ ବିଶ୍ୱାସ କରିବୁନି ଏମିତି କୌଣସି ଡିସିସନରେ କୁହାଯାଏନି ବା କହି ହବ ନାହିଁ everything depends upon the fact of the case ସେଇ ଅନୁଯାୟୀ
But
ଆପଣଙ୍କର
you have to justify. What prevented either the IO not to examine, or there was any such exigency what that prevented the IO not to come to the witness? Because one question has been put. See, what are the questions put to the witness by the defense in the cross-examination is equally very important. So, the questions that has been posed to the IO, if you verify it, and then only you can come to the witness and say how far he is truthful, whether his examination could be possible prior to that, or he is a got up witness. Then what will happen? Ultimately, that means this witness will be a got up witness then. If his evidence will not be acceptable for having examined after 1.5 day, that means he has been planted for the purpose. So what are the other circumstances by which you can say that no, he cannot be said to be a planted witness? But you have to justify these are the circumstances. These are the material in the evidence. Otherwise, how can you say? Apparently, if you say, we see that yes, he might have stated, but his examination is belated. Other corroboration is not there. His evidence does not appear to be a sterling quality. So even if the witness is there, his evidence was to be corroborated by other witnesses. In absence of this corroboration, this witness cannot be said to be a truthful witness.
appreciation ହଉଛି ଗୋଟେ କ୍ରିମିନାଲ କେସରେ ବହୁତ ବଡ ଜିନିଷ ମାନେ ଯୋଉମାନେ ଡିପେଣ୍ଡ କରିଯାଆନ୍ତି ସବୁବେଳେ ସେ ଯୋଉ କେସ୍ ଲ ଉପରେ that is not କେସ୍ ଲ ଠିକ ଅଛି କେସ୍ ଲ ଆପଣଙ୍କୁ ଗୋଟେ ଦବ ଗୋଟେ ଆଇଡିଆ ଦବ କେସ୍ ଟା ସେଇ ଫ୍ୟାକ୍ଟରରେ କେମିତି ବଟ୍ ପ୍ରତ୍ୟେକ କେସ୍ କୁ ଡିପ ରେ ଯିବାକୁ ପଡିବ ଆଉ ଗୋଟେ କେସ୍ କୁ ଡିପ ରେ ଯାଇ ପ୍ରିପାରେସନ ଯଦି ଠିକ ସେ କରିବେ ଆପଣ କନସେପ୍ଟ ଟା ଧୀରେ ଧୀରେ କ୍ଲିୟର ହେବ କ୍ଲାରିଟି ଆସିବ ତାହେଲେ ଯେକୌଣସି ବ୍ରିଫ ଆସିଲା ଧରିବାକୁ ସୁବିଧା ହବ ରୁଟ କୁ ଯିବାକୁ ବାଟ ଆପଣଙ୍କୁ ମିଳିଯିବ ହଁ
There are certain basic things, previous statement, evidence, that we have immediately you can distinguish. Yes, this person has not stated in his earlier statement, has elaborated, or has completely taken a different stand. Then comes your contradiction. If it is not an omission, but only here he is saying akramana hala, kintu attributed that ଭୁଜାଲି ଯଦି ସେ କହିଥାନ୍ତା ଭୁଜାଲିରେ ଆକ୍ରମଣ କଲା ଏବଂ ଏଇଠି କହିଥାନ୍ତା ଯେ ମୁଣ୍ଡକୁ ବାଡେଇଲା yes, this could have been taken because evidence is not 161. Evidence ହେଇପାରେ ଟିକେ ଇଏ କିନ୍ତୁ ଭୁଜାଲି ଧରି ଆକ୍ରମଣ କଲା ଯଦି କହିଥାନ୍ତା ଏଇଠି ଆଣିଥାନ୍ତା ସେଠି କଣ କହିଲା ଆକ୍ରମଣ କଲା ଏଇଠି କହିଲା ଭୁଜାଲି ଧରି ମୁଣ୍ଡକୁ ବାଡେଇଲା. So there is an improvement.
ତା ହାତରେ କୌଣସି ୱେପନ
ସେଠି
ଥିଲା
କହିଲି
161 ରେ ନାହିଁ
So this way you have to prepare, sir. Each and every evidence of the witnesses have to be prepared very minutely between the lines. First 161, then evidence, then comes other circumstances. Why that witness is to believe. Then comes case law. So that is
nowadays you are getting exposure because of this live streaming you are being watched by many so your preparation should be up to that standard
Mr. Naik was the other day he was telling that yes, he was in this spot. Where is your argument? Why it is not in this spot? If you argue this witness was not in this spot, thank you. So we have to justify from the evidence. So what kind of evidence is before you? Acceptability of a particular evidence is different. That is appreciation. But you have to bring the case from your side. से कहला 15-20 फीट दूर रे अछि साइकिल रे देखुतला दूर देखिला आ डरी करी पळेला साइकिल छाडी दी तो शुड इट बी टेकन एज ए स्पॉट अदर विटनेस कहले ता पर दिन पीडब्ल्यू4 हुई जे इन्फॉर्मेंट से कहूजे आगा से डेड बॉडी पाखरे थिला ताकू से पचारिला जे बापंकर हत्या केमिति हला ही सेड दैट ही इग्नोर इट so why pw4 will be believed and the pw10 will not be believed because pw4 credibility is somehow not consistent because he is not supporting the FI. So you have to come, you have to justify. How doubtful hota ho, sabu hota, but you have to bring a case first.
April, there are, I think, 4 councils are there attached to this case. You must be distributing the brief between yourself. So, ଆପଣ ମାନଙ୍କୁ ଗୋଟେ ୱିକରେ କେତେଟା ଫାଇନାଲି ଡିସ୍ପୋଜ କରୁଛି ଆପଣ ମାନଙ୍କୁ ସ୍କୋପ ମିଳୁଛି ମାନେ ପ୍ରିପାରେସନ କରିବାକୁ thoroughly and we are giving you patient hearing we are discussing the case otherwise we'll just hear and just reserve the judgment, we'll pass the order. It's very easy then. It's not that we, after 15 minutes we can reserve the one judgment. What is there? But it should not be there.
We have grasped it. We have grasped it. It takes only 15 minutes, but we are not doing that. At our cost, lest we are said that yes, we are not disposing. May not be. But it is a question of the life and death of a person.
What do you say? Close the argument and
Tuesday I will
taken time. ଗୋଟେ ୱିଟନେସ୍ ଆପଣଙ୍କର ତାକୁ ପ୍ରିପେୟାର ଆପଣ କରୁନାହାନ୍ତି ଆଉ ସବୁ ସାକ୍ଷୀ ହୋଷ୍ଟାଇଲ ହେଇଛନ୍ତି ଆଉ କାହାର କିଛି ଏଭିଡେନ୍ସ ହିଁ ନାହିଁ ବାକି ସବୁ ପ୍ରାୟ ହୋଷ୍ଟାଇଲ ହେଇଛନ୍ତି ଏକ ହୋଷ୍ଟାଇଲ ଦୁଇଟା କିଛି କହିନି ତିନିଟା ହୋଷ୍ଟାଇଲ ହେଇଛି ଚାରି ଏଭିଡେନ୍ସ କିଛି ନାହିଁ ପାଞ୍ଚ ହୋଷ୍ଟାଇଲ
Only 10 and IOs. W4 is inconsistent. Still, it has relevance because some facts have been brought in the crossover. ସେ ଯୋଉ କହିଛି ପ୍ରଶାନ୍ତ ବେହେରା ଥିଲା ସେଇଠି ଯଦିଓ ସେ ଏଫଆଇଆର ରେ କହିନଥିଲା ଯେ କାହାଠୁ ଏମାନଙ୍କୁ ଶୁଣିଛି ବୋଲିକି କିନ୍ତୁ ସେ କହିଛି
आईओ एविडेंस देखंतु पैराग्राफ नंबर 32 पेज 95 पेज 9 evidence paragraph 32
Prior to exemption of the PW10, I had no knowledge about the eyewitness for the case. I cannot say if
ନାଇଁ ସେତିକି କଣ ସେ ଏଇ ଗୋଟେ ସେଣ୍ଟେନ୍ସ ର କେତେ ଇମ୍ପୋର୍ଟାନ୍ସ ରହିଛି prior to examination PW10 I had no knowledge about the eyewitness of the case ଏଇ କେସ୍ ରେ କୌଣସି ପ୍ରତ୍ୟକ୍ଷଦର୍ଶୀ ସାକ୍ଷୀ ଅଛନ୍ତି ବୋଲି 10 ସାକ୍ଷୀକୁ 10 ନମ୍ବର ସାକ୍ଷୀକୁ ଏକ୍ସାମିନ କରିବା ପୂର୍ବରୁ ମୋର କୌଣସି ଧାରଣା ହିଁ ନଥିଲା ଯଦିଓ ସାକ୍ଷୀ କହୁଛି ମୁଁ ଆକୁ କହିଲି ତାକୁ କହିଲି ଇଏ କହିଲି ମୁଁ ଗାଁରେ ଥିଲି ସୋ କମ୍ପ୍ଲିଟଲି 36 ଘଣ୍ଟା ଯୋଉ ଆପଣ ସେ ପର୍ଯ୍ୟନ୍ତ ଏ ଲୋକର ଧାରଣା ହିଁ ନାହିଁ you sacrifice for the file କରୁଛୁ ଗୋଟେ ସେଟା ପଢାଉ ସେଟା ଆମେ ରିଜେକ୍ଟ କରୁଛୁ dictated it on target file number 1 of 2025 subsequent trial exam ହେଲା the witness ସବୁ ତ ମନା କରିଦେଲା କଲା ତାପରେ obviously he was declared hostile by the public prosecutor ତ confront କରିଛନ୍ତି ଏଇ trial ର statement ଗୁଡାକ ତ ମୁଁ ସେଟା କିଛି ମନେ ରଖିନି case but I don't remember to have stated in my evidence as such as well.
He admitted that he has given the discussion in the ST case number such and such, but I do not remember.
One name, more one. ଆଉ ତାପରେ ଯୋଉ chief ର ଯୋଉ statement ଟା ଦେଇଛି I know the accused.
Yes.
I know the deceased. I do not know anything about the case. Very positive. बाकी गला अब मोर किसी मन ना ठीक तरह से दिला खलास है because of this legal hurdle we rejected that petition but evidence is before us. What do you say, Mr. Yeah. Have you got anything to say or close?
I know yesterday your lordship wanted to my associates to find out some decisions whether on ground of delay. Exactly, Justice P.N. Bhagavati has decided a case one exact 1.5 days delay, and he has not relied on the evidence of that too. Yes, my lord. And also from that is also from a case of Orissa, my lord.
77, yeah, 77.
Yes, my lord.
76.
Stenkanal case. Brahmananda Gond.
Brahmananda. Brahmananda.
এটা भी देखो दे रहा था जड़ दिन पड़े the leading decision from Odisha. Three grounds is decided. जड़ दिन पर्यंत साफ ये करता जब भी उसे कौची disclose करुची में लेकिन तो किसी corroborating evidence नहीं. ଛଅଟା ଲୋକ ଆଜିରେ ମର୍ଡର ହେଇଥିଲେ ଡେଥ୍ ସେଣ୍ଟେନ୍ସ ହେଇଥିଲା ଆଉ appeal acquittal ହେଇଥିଲା state ଯାଇଥିଲା. You see the ଯୋଉଟା underline କରିଛନ୍ତି the murders were committed in the night of June 13th 1969. She did not come out with the name of the respondent until the morning of June 15th 1969. Exam 8 that is it is not possible to accept the explanation sought to be given on behalf of the prosecution that she did not disclose the name of the respondent as the assailant earlier than so and so on account of fear of the respondent. There could be no question of any fear from the respondent because in the first place, the respondent was not known to be a gangster or a confirmed criminal about whom people would be afraid. Secondly, the police had already arrived at the scene and they had stationed the clubhouse, which was just opposite to the house of the witness. And thirdly, ASI and was her nephew and he had come to the village in connection with the case and also visited the house. It is indeed difficult to believe that this witness should not have disclosed the name of the respondent to the police or even to the ASI so and so, should have waited till the morning of so and so for giving out the name. This is a serious infirmity which destroys the very credibility of the evidence of this witness. ସେଥିପାଇଁ High Court କୁ order ଟାକୁ confirm କଲେ acquittal order ଟା. This was from Dhenkanal, ADJ Dhenkanal death sentence ଦେଇଥିଲେ 6 murders. Later.
So, sir, finding to your also
Highly
another decision 3 days delay.
Yeah. 19. 1976 court SCC case कहते हैं 280 288 state of Orissa versus Nando ଆଉ କଣ
10 days delay.
10 days 10
days, 3 days, 4 days is not.
that is not
And even delay is not important. Important is how far it is accepted.
sensible. ଆମେ ସେଇଥିପାଇଁ ଯୋଉ delay
I also sought one decision that the person to person verify that some person.
We have delivered in a death sentence case. That lady was examined 7 days after. That was the sole witness that the Guhal Bandi Dele. Guhal Bandi Degin Tinita murder, triple murder. Her family, because only buried Kone, Puni buried Korin, out there bar Korin, out of their 40 Dele. The explanation ଦେଇଛି କଣ ପାଇଁ ହେଇକିନି ସେଇ explanation ର 7 ଦିନ delay ହେଇଥିଲା. They have accepted it to elaborate that
That's from Raigada.
Raigada, right. Raigada. Can find
There are many such cases when we were dealing with mob cases in Fulbani, Kandhamar. How can you expect a person to be examined who are hiding themselves, being panicked? You cannot expect that the witnesses can be examined.
You see, even in the gangsters case of Qatar,
Yes,
the witnesses
Yes.
are coming at a belated
Yes.
stage, and even they
You
give
can't
in their
expect.
statement, they are denying it in
Yes.
court, and that is the reason why most of the cases are ending in acquittal. Most of the cases. So they have a fear psychosis. They have a gangster. You will feel what would happen even if you tell direct ଆମ family ଅଛନ୍ତି ତାଙ୍କୁ କଣ ହବ ତାଙ୍କର ଏଇ ଯୋଉ ଜିନିଷ witness protection ସେଲ୍ ଆସିଲାଣି ଇଏ ହେଲାଣି ଏ ସବୁ ଭିତରେ ତାଙ୍କର ଯୋଉ ଭୟଟା ରହିବ ସେଇଟା କିନ୍ତୁ ତମକୁ ଦେଖିବାକୁ ପଡିବ ଇଏ ଆକ୍ୟୁଜ ଟା ସେଇ ଟାଇପ ର
Yes.
ଯୋଉଠି ସିଏ ବି threaten ନ ଦଉ କିନ୍ତୁ ଲୋକଟା
ସେଇଭଳିଆ ଥିବ.
ଗୋଟେ
Yes.
ତାର ଗୋଟେ ଫିୟର ସାଇକୋସିସ୍ ସେଇଥିପାଇଁ ସେ that is the wording ସେଥିରେ କୁହାଯାଇଛି is not a gangster ଏଠି ଏମାନେ ଆପଣ କିଛି ଆଣୁନାହାନ୍ତି ନା ଯେ ନା ଏଇ ଯୋଉ ଲୋକଗୁଡାକ ମାନେ ଆକ୍ୟୁଜ
History
ଯେମିତି
sitter ଥିଲା, ତାର ଆଗରୁ ଏମିତି
ଇଏ
ଅଛି.
ଥିଲା ତାହେଲେ ଗୋଟେ ଅଟୋମେଟିକ ଗୋଟେ ଫିୟର ସାଇକୋସିସ୍ କ୍ରିଏଟ ହବ ସିମ୍ପଲ ଗାଁ ଲୋକ ତ ଗାଁ ଲୋକ ଯୋଉଠି ପୋଲିସ ଆସିଗଲାଣି ଇଏ ଚୁପଚାପ ଅନ୍ୟମାନଙ୍କୁ କହୁଛି ପୋଲିସ ପାଖକୁ ଯିବା ଏଇ ଯୋଉ ଜିନିଷ ଗୁଡା ଏଗୁଡାକ ଆପ୍ରିସିଏସନ ଜିନିଷ ଗୁଡାକ ଯୋଉଟା କି ସେଇ କେସ ରେ ମଧ୍ୟ ସେ highlight କରାଯାଇଛି
that part also the honorable apex court held that the different persons has different thought. Some person has the outspoken, they are saying in the immediately, they have some person in
one
the
aspect that is
calm
you are
and
right.
quiet, and that aspect the court has held that on the ground of soul, the soul eyewitness that evidence of the soul eyewitness cannot be discovered.
ମୁଁ ଯଦି ସେଇଟା ନୁହଁ ଯଦି ମୁଁ ସେମାନଙ୍କର ନାଁ କହିବି ତାହେଲେ ମୋର ଯଦି ଭୟ ରହିଲା ତାହେଲେ ମତେ ସେ ଫ୍ୟାମିଲି ଉପରେ ଇଏ କରିବେ ତାହେଲେ ମୁଁ କାହାକୁ ଡିସକ୍ଲୋଜ କରିବିନି ମୁଁ ଯେତେବେଳେ ଯାଇ ମୋ ଗାଁ ଲୋକଙ୍କୁ ବି କହୁଛି ଗାଁ ଲୋକ ଯାହାର ଏଇ ମାନେ ମାରିଦେଲେ ତାହେଲେ ତ ମୁଁ ଡିସକ୍ଲୋଜ କରୁଛି ତାମାନେ ମୋର ସେ ଯୋଉ ଭୟ ହିଁ ନାହିଁ ମୁଁ ଡିସକ୍ଲୋଜ କରୁଛି ଆଉ ସେମାନଙ୍କ ତାହେଲେ ପୋଲିସ ପାଖରେ କାହିଁକି ନ କରିବି ଯଦି ସିଏ ତାର ଷ୍ଟେଟମେଣ୍ଟ ହିଁ ଆକ୍ସେପ୍ଟ ହୁଏ ଗାଁ ଲୋକଙ୍କ ପାଖରେ କହୁଛି ଓପନ ଅପ୍ କହୁଛି ଏଇମାନେ ସେ ତାକୁ ମାରିଛନ୍ତି ମୁଁ ଦେଖିଛି ତାହେଲେ ଇଜ ଓପନିଂ ଅପ୍ ନା ତାହେଲେ ତାର ତ ଆଉ ସେ ପିଓର ସାଇକୋସିସ୍ ନାହିଁ ସେ ଚୁପ୍ ହେଇ ରହିଯାଉ ହଁ ତେଣୁ ସେଠି ଆପଣ ପୋଲିସ ପାଖରେ ତାହେଲେ କଣ ଅସୁବିଧା ଥିଲା
that time the case must have to be built up like that. He came, did not talk to anyone, kept mom and alone stayed in the home. Then he disclosed one of the family member, and the police came, and the family member is also examined, saying that କାଲି ରାତିରୁ ଆସିଲାରୁ ଏ କଥା ହଉନଥିଲା ଏଇ ଭୟରେ ସେ ଥିଲା ଯେତେବେଳେ ପଚାରିଲୁ କହିଲାରୁ ଗଲା yes you otherwise how can all of a sudden ସେ କହୁଛି ତାକୁ କହିଲି ପୋଲିସ କହିଲା ବେଳକୁ ଯିବନି ତାପରକୁ ଆମେ ଫେର ଦେଖୁନା ନ ଦେଖିଲେ ବି ତ ଅଛି ନା ଗୋଟେ କଣ୍ଡକ୍ଟ କହୁଛି ନାଇଁ is it that the accused persons are so dangerous or they were just villagers out of some dispute they killed one so ସେ କ୍ଷେତ୍ରରେ ତା ଡରଟା ହେବାର କିଛି ନାହିଁ
they are of the political rivalry, they are
might be political rivalry is not
ସେ ଯୋଉ କେସ୍ ଟା କୁହାହଉଛି ତା ଦେହରେ 3ଟା ମର୍ଡର କରିବା ପରେ ତାଙ୍କୁ ବରିଡ୍ କଲା ପରେ ତାକୁ ଆସିଲେ ତାଙ୍କର ଯୋଉ କଣ ଇଏ ହୁଏ ସେ ଝିଅକୁ ନେଇକି ଯାଇ ସେ ଯୋଉ ଭାତ କଣ ତାକୁ ଇଏ କଲେ ସେ ଝିଅଟାକୁ କନଫାଇନ୍ କରି ରଖିଲେ ତାର ଝିଅ ମାନେ 3ଟା ଡିସିଜ ଭିତରୁ 2 ଜଣ ତା ବାପା ମା ଆଉ ଗୋଟେ ତାର ଭାଇ ନା ଭଉଣୀ ତାକୁ ଗାର୍ଡ କରି ରଖିଲେ ସିଏ 6-7 ଦିନ ପରେ ଖସିକିନି ପଳେଇ ଆଇଲା ଆସିକିନି ରିପୋର୍ଟ 7 days ପରେ ରିପୋର୍ଟ ହେଲା
and she was staying in a remote village the police station is almost 40 or 50 kilometers away from that
so it depends upon that
ତାପରେ entire village was against them entire village was against them
ସେ ବାହାରି ପାରିବନି ସେ ଘର ମାନେ 25ଟା ଜମା ଘର ସେ ଗାଁରେ 25ଟା ଘରରୁ ଏମାନଙ୍କ ଏଣ୍ଟାୟାର ଭିଲେଜର ସବୁ କାରଣ ତାକୁ ୱିଚକ୍ରାଫ୍ଟ କରୁଛନ୍ତି ବୋଲି ସେ ଇଏରେ ତେଣୁ ସମସ୍ତଙ୍କ ନଜରରେ ଅଛି କୁଆଡେ ଯିବ ଖସିକି ଯିବ ଇଏ ବାହାରି ପାରୁନି ସେଇ ସର୍କମଷ୍ଟାନ୍ସରେ ଦିନେ ସକାଳୁ କେମିତି ଗାୟବ ହେଇଯାଇକି ଆସିକି ପୋଲିସ ଷ୍ଟେସନରେ ପହଞ୍ଚିକି ଆସି ରିପୋର୍ଟଟା ଦେଇଛ that was the explanation that this point was raised that
and out of many 9 persons were awarded the death sentence which was again reduced to life
କଣ କରିବା କଣ କହୁଛନ୍ତି କୁହନ୍ତୁ you want to tell something on Tuesday ରଖିବା ମଙ୍ଗଳବାରକୁ ନା କ୍ଲୋଜ କରିଦବା ଆପଣ ଯାହା କହିବେ
ଯଦି କରିପାରିବେ ଠିକ ଅଛି yes sincerely you try for it otherwise
we'll keep on Tuesday.
All right but we will not grant further time if you have further arguments you should petition now to the additional government and sort for an adjournment to submit suicide some decision and should file written note of this matter on 18th of November 2024. ଆଉ ଗୋଟେ ରହିଥିଲା ଆପଣ ଡିସିସନ ମିଳିଲା
Decision I can
ଏଇ ତ ଆପଣ ଡାଉରୀ ଡେଥ୍ କେସ୍ ରେ ଡେଡ୍ ବଡି ଡିସ୍ପୋଜ ଅଫ୍ ହେଇଛି decision ପାଇଲେନି.
How do you say? Several decisions.
Have you searched ମନୁପାତ୍ର?
ଡାଇଜେଷ୍ଟ ଗୁଡା ସବୁ ଅଛି।
Digest ପାଇବେ ଏବେ ଆଉ ଆଜିର ଦିନ
ଯୋଉଟା protagonist ଅଛି।
ଆପଣ ଆମେ ସେଦିନ କହିଲୁ ଆପଣ ପାଇଛନ୍ତି ମନୁପାତ୍ରକୁ ଯିବେ ମନୁ ସର୍ଚ୍ଚ କୁ ଯିବେ ମାରିବେ ଡାଉରୀ ଡେଥ୍ ଡେଡ୍ ବଡି ଡିସ୍ପୋଜ ଅଫ୍ ହେଲା କ୍ଲିକ୍ କରିଦେବେ ଆପଣ ମାନେ ଭାବୁଛନ୍ତି ଯେମିତି ଏଇଟା ଇଣ୍ଡିଆରେ ପ୍ରଥମ ଥର ପାଇଁ ହେଲା ଗୋଟେ ଡାଉରୀ କେସରେ ନେଇକିନି ସେ ଡେଡ୍ ବଡିଟାକୁ ପୋଡି ଦେଇଛନ୍ତି ଶହ ଶହ ଡିସିସନ କଣ ଆପଣ କୋଉ ଯୁଗରେ ଅଛନ୍ତି ଏତେ gone are those days when we are searching for this କଣ ଡାଇଜେଷ୍ଟ ପ୍ରତ୍ୟେକ ଖାତା କାଢୁଥିଲୁ ସେଥିରେ ବି ନ ମିଳିଲେ ଗୋଟେ ଗୋଟେ ବହି କାଢିକିନି ଦେଖୁଥିଲୁ ରାତି 1-2 ପର୍ଯ୍ୟନ୍ତ gone are those days this you see this so many things are available with you and if you will not utilize them ଆପଣ କହୁଛନ୍ତି ଯେମିତି ଏଇଟା ଗୋଟେ ଡାଉରୀ ଡେଥ୍ କେସ୍ ଡେଡ୍ ବଡିଟାକୁ ନେଇ ପୋଡି ଦେଇଛନ୍ତି କ୍ୱେଶ୍ଚିନ୍ ହଉଛି whether it is a ସେ ଷ୍ଟାଣ୍ଡ ନେଇଛନ୍ତି ନ୍ୟାଚୁରାଲ ଡେଥ୍ ହେଲା ତାପରେ ପୁଣି ନେଉଛନ୍ତି ସୁଇସାଇଡାଲ ଡେଥ୍ ବଟ୍ କନଭିକ୍ସନ ହେଇଛି 302 ଏବଂ 304 we are putting you a question that how the prosecution will surely has say that it is not a case of suicidal death but it is a homicidal death କଣ ଆପଣଙ୍କର ମ୍ୟାଟେରିଆଲ ଅଛି ଏଠି ତ କେହି ଆଇ ୱିଟନେସ୍ ଓବିୟସଲି ଆସିବେନି କାରଣ ଫୋର କର୍ନର୍ସ ରେ ହେଇଛି ଏବଂ ଡେଡ୍ ବଡି ଡିସ୍ପୋଜ ଅଫ୍ ହେଇଯାଇଛି ସୋ ମେଡିକାଲ ଏଭିଡେନ୍ସ ବି ନାହିଁ ତେଣୁ ଏଠି କାହିଁକି ତାଙ୍କୁ 304 B ରେ ଆମେ କାହିଁକି କନଭିକ୍ସନ କରିବୁନି ଯୋଉଠିକି ଅନ୍ୟ ଇନଗ୍ରେଡିଏଣ୍ଟସ ଗୁଡାକ ସବୁ ମେକ୍ ଆଉଟ୍ ହଉଛି ଆମେ କେମିତି କୋଉ ବେସିସ ରେ କରିବୁ ଯେ ଏଇଟା ଗୋଟେ ହୋମିସାଇଡାଲ ସେତିକି ହଉଛି କଥା ମାନେ କଣ ଆପଣ ଡିସିସନ ପାଇଲେ ଲେଟ୍ ଅସ୍ ସି କୋଉ ପାରାଗ୍ରାଫ କୁହନ୍ତୁ ମିଷ୍ଟର ପ୍ରଧାନ ପାରାଗ୍ରାଫ ନମ୍ବର ଆପଣ 2 କୁ ଆସନ୍ତୁ ଯୋଉଠି ଫ୍ୟାକ୍ଟ ଲେଖା ହେଇଛି The case of the prosecution unity. Paragraph 2.
Madam,
Hold on.
the case of the prosecution in brief is that the deceased Rebecca alias Tai, daughter of Dottoro, resident of village Umateori, was married to the appellant. Rimuk Murthy
Remuk Maruti Kirtan.
Nearly 7 years before the incident, which took place on 4/11/1996 in village Kikimurti.
No, in village
Kiki.
Maruti Kamaji
Kirkan is the father
Nilavati Bai.
and Nilavati Murthy Kirkan is the mother of the appellant. Trimuk and they are residents of village Kiki. The appellant, who is the husband, and Murthy and Nilavati used to irritate the deceased. Revant and used to harass her on account of non-payment of 25,000 by her parents for the purpose of purchasing a tempo for the appellant. Whenever the deceased Revant came to her parental home, she used to disclose on her family members the ill-treatment and harassment meted out to her. She came to her parental home at the time of Panchami festival in the year 1996 and stayed there for about 15 days. During this period also, she disclosed that on account of non-fulfillment demand of 25,000 by her,
This is not your case. This is the dead body ଅଛି postmortem ହେଇଛି
Dead body ଅଛି no?
Dead body ଅଛି postmortem ହେଇଛି. This is not.
This is not. We want a case where the dead body has been disposed of. Sorry. এই ସେ ଯୋଉ ଇଏଟା ମନୁ ପାତ୍ରଟା କେମିତି ଦେଲା ମତେ ସେଇଥିରେ ବାହାରିବ এটা କନେକ୍ସନ ଅଛି ତ ଟାଇପ ହେଲେ ବାହାରିବ କି ମାନେ କର ଟାଇପ କର ଆରେ ଏବିସି କର ହଉଛି ଦିଅ ସେଇଥିପାଇଁ ଅନ୍ କରି ତା ଅଛି ନା ଠିକ ଅଛି ଠିକ ଅଛି ଗୋଟେ ଲଗଇନ୍ କର ପାସୱାର୍ଡ ଦିଅ ଗଲା मेरा हो ही ना
ଏଇଟା ଗୋଟେ ଇଏକୁ ଗୋଟେ
ବ୍ଲକ୍ କରୁଛି
ୟୁଜ ହଉନାହିଁ ତ ଫିଙ୍ଗର ଗୁଡାକ ଲଗଇନ୍ ଆସୁନି
ଯାହା ଟାଇପ କର वाई वाई कौन लिखला आर वाई डेट डेट बॉडी